Order and ask everybody to rise as you're able to join us in the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Do you want to sing?
Maya would.
All right. First order of business is House Bill 1694, and I will open the hearing on that bill and recognize Representative Wade to introduce it.
Thank you, Mr. Chair. Good morning, members of the committee. I am Representative Alice Wade, here representing Dover Ward 2, Stratford 15, and I'm here today to introduce my data privacy bill, HB 1694. Every day, private companies collect and sell our personal information without our knowledge or consent. These data brokers build detailed profiles on nearly every Granite Stater, tracking what we buy, where we go, and what we search for online. We all value our privacy, but many people don't realize how much they're being watched. Data brokers collect browsing data from shopping sites, news outlets, social media, and anywhere that uses third-party trackers. They use that information to build detailed consumer profiles. Sometimes this data is used for marketing. For example, a company might target wedding ads to people who got recently engaged or baby products for those expecting a child. But it can also be used for more dangerous purposes. People search websites, sell addresses, phone numbers, and personal information to anyone willing to pay, which has allowed domestic abusers and stalkers to track their victims even when they go out of state. This is a multi-billion-dollar industry operating entirely without the consent of the people whose data they sell. Public estimates have reported upwards of 1,000 active data brokers in the United States today. New Hampshire has taken some positive steps to give residents data privacy rights, the right to request copies of data, to delete it, and to opt out of collection, but those rights are difficult to exercise when you don't even know which companies have your data. That's why I've introduced this bill, modeled on Texas's new Data Broker Act. It would require data brokers operating in New Hampshire to register annually with the state, disclose their data practices, and maintain basic cybersecurity standards. My bill adds one key improvement. It would create a simple online portal on the Secretary of State's website where any resident can make a single request to access, delete, or opt out of data collection across all registered data brokers. The state would then forward that request to all the registered companies at their designated contact information, which they must respond to within 15 days. However, I recognize that this specific aspect of the bill has significantly raised the fiscal note more than I anticipated. I have a bit of background in programming, and I believe it could be done significantly cheaper, but if the committee needs to amend this bill to reduce the fiscal note while keeping the data broker registry, I'd be happy to work with any committee members interested in doing that. That would still go a long way towards improving data transparency in the state. Right now, for-profit companies charge people subscription fees to request their own data deletion. There's no reason that that should cost money. Privacy should be a right and not a luxury. Texas launched its registry just last year and has already registered over 300 companies. I think it's time New Hampshire followed their lead. Data privacy is something that many of us value, but in some ways have given up on being a reality. This bill is a practical, bipartisan step towards giving Granite Staters real control over their personal information. I urge the committee to support it, and I'm happy to answer any questions.
Thank you. Are there any questions? No? Representative Birch.
Thank you, Mr. Chair. Thank you for taking my questions, Representative. Two areas I have questions about. One is the application of this. So we would be attempting to regulate these data brokers worldwide, folks, if they're collecting any data on Granite Staters, or if they are operating the Granite, I mean, who has to sign in on this?
Yes, so I'll need to find the specific section. This was modeled off of Texas's exact language for the cybersecurity and other portions of that. Just one moment. Let's see if I can find that in the bill. I know that that specific criteria is within the language. I just need to find it.
And I was looking at the first real page of the bill at 19. It says it's of residents of the
Yes.
state. I just didn't know
Mhm.
what data brokers have to
So-
comply with this.
Yeah, so it would be basically if you collect information on a Granite Stater, and yeah, so I believe that would count for those companies, so long as they collect information from Granite Staters. It seems to be working all right for Texas, at least so far. But if that's a concern, if there would be a stricter criteria that would help address those concerns, then I'd be open to that.
Just to clarify, you're saying if it's a data broker in the state of Washington operating nationally, they would have to comply with this if any of their data came from, was relative to a citizen of this state.
Correct.
And my second question, if I could follow up.
Follow up. This is your third, I think.
Caught me again. Caught me again. All right, so you use the idea of somebody getting married, they put their announcement in the newspaper, and data brokers access that and use it for whatever advertising or data collection purposes they have. I'm wondering about the issue of waiver. If I am getting married and me and my intended put it out there in the public, do we have privacy protection for something that we have voluntarily decided to let the entire world know?
So I'll give you two examples of how this actually works with these companies. Typically, it's not them necessarily scraping newspapers. They might be able to basically directly track your shopping history, whether it's from your credit card, online shopping. These third-party trackers can basically pick up on your browser on one web page, and then they can determine, if you go to one news site, it adds a third-party tracker. Then you go to shop on Amazon, and it can tell what you buy on Amazon, what you're searching for. So in the example of a wedding, maybe they don't even announce it publicly. Maybe they just found the shopping history of a boyfriend who just bought an engagement ring. That wasn't public information that you volunteered to give up. That was your private shopping history. Another example of the way this was actually almost kind of scary to realize is I don't recall the exact state it was in, but there was a news story about a father who called the Target offices because he was angry that they were sending his teenage daughter baby supply advertisements. They like baby food or baby clothes and things like that. And he was angry because why was Target, trying to advertise these products to his daughter who wasn't pregnant? Well, it turns out she was pregnant, and Target's tracking found out before her father did because of her subtle shopping habits changing. That wasn't even public information within that family, and yet Target's algorithm was able to determine purely off of shopping habits alone that she was pregnant. There are incredibly small subcategories, and these algorithms are that sophisticated. It's not just publicly saying, "Oh, this person announced their wedding, so let's advertise to them." It goes much deeper than that. So that's more how these systems operate generally, even with private information.
Representative Alexander.
Thank you, Madam Chair. Thank you, Mr. Chair. Thank you for taking my question. I'm wondering about how we enforce this with like multinational companies or companies that are in China. I see the penalty section says may not exceed $10,000, but like, how does the attorney general go after like Huawei or like a Chinese company? I just don't see that being possible in our capacity in our attorney general. Although he, does a lot of work, but I don't think he can handle taking on Chinese companies.
Exactly. So, generally, this is data brokers operating in the U.S. So that would be companies based in the U.S. for the most part. Again, a lot of this eligibility criteria is strictly based off of Texas's. I did not modify that for this. The section that I did modify was the section regarding having an online form for any granite stater to go on the Secretary of State's website, fill out their information, and forward that data request to all of those data brokers. Texas has registered about 300 just in their first year of operating. And you multiply that 300 by whatever that annual fee is, and that does bring in a bit of revenue to cover the costs of operating the registry. So I would imagine, for the most part, in terms of enforcement, this would generally apply to U.S. companies. Practically speaking, if there's a better way to address that, I would be happy to look into that.
Any other questions? Seeing none, thank you.
Thank you very much.
Yep. Zachary Taylor?
Good morning. Thank you for the opportunity to be here. I'm Zachary Taylor. I'm with the Consumer Data Industry Association. I have a copy of my written testimony, which I previously submitted, if you'd like me to pass it out before I begin. All right. Consumer Data Industry Association represents the consumer reporting industry. Our members include the credit bureaus, background check companies, tenant screeners, and businesses engaged in identity verification and fraud detection services. We are respectfully opposed to 1694 because the core provisions of this bill are already existing in the state's comprehensive data privacy statute that focuses on activities, not arbitrary business models, the way the data broker definition does. So the definition of the bill exempts those data aggregators that have connections directly to the consumer, thereby exempting the vast majority of companies who are collecting consumers' data from having to register under this bill. Given that the state already has a comprehensive data privacy statute, there's nothing inherent in the activities of these companies that requires them to register. So we believe that the provisions in this bill, particularly around the portal, are unnecessary. And I would note that those portal provisions do not come from Texas. They come from California's Delete Act, which has cost the state millions of dollars to try to implement. There are millions of companies engaged in collecting consumer information for a variety of lawful purposes. California's registry includes several hundred. So you can understand from that discrepancy that this bill would not actually do a good job in terms of helping consumers identify who may have their data, but it does create confusion. It includes a private right of action. It includes prescriptive cybersecurity requirements for a subset of companies dealing with consumer data, but it excludes the vast majority of companies dealing with consumer data. That doesn't make a whole lot of sense to us. Most importantly, we would encourage the state to continue to allow its comprehensive data privacy statute to take effect, which has attorney general enforcement. It took full effect on January 1 of this year when the right to cure period expired. So in conclusion, we have serious concerns about this bill, both some of the requirements placed on a subset of companies that are engaged in lawful activities, but their data is overwhelmingly exempt because of the clear exemptions in existing statutes. So it's a little confusing to us what the intent is here when so much of the data it contemplates is already exempt. Would we have to be notifying consumers that they don't actually have a right to opt out because, for example, our data that's governed by the Federal Fair Credit Reporting Act or the Gramm-Leach-Bliley Act that have clear consumer rights, clear opt-out provisions, clear privacy protections, and others. So I thank you for your time today. I'm happy to stand for any questions and respectfully urge you to find the bill inexpedient to legislate.
Thank you. Any questions of this witness? Seeing none, thank you.
Thank you.
Is there anyone else here that wishes to speak on this bill? You can fill out a pink card? Yep, okay. You can pass that pink card down here.
Printed out copies of my testimony if you.
You can turn that at the end as well. And then just identify yourself and you can go ahead.
Good morning, everybody. My name is William Chanez Martinez. I'm an associate attorney with Mariner Strategies, where I serve as counsel to the State Privacy and Security Coalition. SPSC is a New England-based multi-sector coalition of more than 30 companies and 7 trade associations. We work with legislators and regulators across the country to develop data privacy frameworks that protect consumers, drive consensus among businesses and stakeholders, and promotes interoperability across the states. We were very proud to be part of the process that helped New Hampshire's data privacy bill get across the finish line. So again, thank you for allowing me to testify today. At the outset, I want to be clear that SPSC is not taking a position today on the data broker registration provisions in HB 1694. Our concern is narrower. We are here to respectfully oppose the bill because it would fundamentally change New Hampshire's comprehensive privacy law by giving consumers the right to opt out of processing of personal data for any purpose. That phrase sounds simple, but in practice, it creates a major problem. It does not just limit targeted advertising or the sale of data. It reaches a basic processing that allows everyday services to function safely, reliably, and legally. It also undermines the heightened protections that New Hampshire's enacted to protect sensitive data, namely opt-in protections for processing sensitive data like biometric data, precise geolocation data, and children's data. New Hampshire's law follows the same approach as every other state with a comprehensive privacy statute. In addition to the heightened protections for opt-in controls of sensitive data, consumers have the right to opt out of specific activities, such as the sale of personal data, targeted advertising, and certain automated decision-making. At the same time, the law recognizes that some processing must continue in order to provide a product or service, protect against fraud, secure systems, or comply with legal obligations. HB 1694 removes that limiting principle, and that is what makes it unworkable. To make this concrete, I want to offer 2 real-world examples. First, fraud prevention. If you've ever received a text message that says, "Was this you?" after a suspicious login attempt, that is a company processing personal data to protect your account. They may look at unusual login locations, device information, or repeated failed password attempts. Under an opt-out for any purpose framework, it would be unclear whether a business can continue that kind of fraud detection once a consumer opts out, because that is still processing. Second, account functionality. Think about ordering a product online. A business has to process information like your name, email address, shipping address, and payment details to complete the transaction and deliver the service. An opt-out for any purpose raises a practical question. Does the company have to stop processing even the data needed to fulfill the consumer's request? HB 1694 makes that answer unclear. The practical effect is that HB 1694 collapses the distinction between modern privacy laws that rely on processing that is discretionary, like targeted advertising, and processing that is necessary to provide services, protect consumers, and comply with the law. For these reasons, we respectfully urge the committee not to move HB 1694 forward in its current form. Thank you very much for your time and consideration, and I'm happy to take any questions.
Thank you. Are there any questions? Nope, seeing none, thank you very much.
Thank you very much.
That was for the next bill.
That's the next one. Oh, that's it.
Do you want me to get IT up here?
Morning, Chair, Mr. Committee. My name is DJ Burke. I'm here on behalf of the Business and Industry Association, the State's Chamber of Commerce and Manufacturing Association. I'll keep my comments extremely brief this morning. The BIA does not have an official position at this time on this bill. The main reason for that being that we go through a deliberative process for every bill that we take a position on. We have not had the opportunity to do that on this bill. So it is possible that we will change our position in the future, but right now we are not taking a position. Something I wanted to point out is that BIA was supportive of the comprehensive privacy bill that was recently enacted. And we would just urge caution to the committee in making changes to the bill, especially so soon after it's been adopted. A lot of the decisions that were made in coming to the agreement with the comprehensive privacy bill were deliberate, and it was a delicate balance in finding something that was both beneficial to consumer protection as well as in the best interest of businesses. And one other thing I'd like to note is that while our law mirrors that of 19 other states, none have adopted a similar provision to the one that's included in this bill. So that is my full testimony. If you have any questions, I'll be happy to answer.
Thank you. Are there any questions? Seeing none, thank you very much.
Thank you very much.
Anyone else here that wants to speak on this bill that hasn't turned a pink card in? Seeing none, I'm going to close the hearing on House Bill 1694. And I think we are at a point where we can hold an executive session on this. I think we're all in agreement, so I will open up an executive session. Once the clerk is ready on House Bill 1694. Yes.
I just have one comment that I want to make on this bill and on a number of others that are coming before Judiciary. We, of course, as members of the New Hampshire House, are concerned about costs. We're always concerned about costs. The only point I want to make is that it's really the Finance Committee that in the end has to worry about that. So that in our making our decision on any bill here, while we can consider costs, I think we should focus on the policy and let the Finance Committee worry about the costs. And I just thought I'd like to mention that before we go on to act on any bills.
Thank you. I agree with you. All right, is there any discussion on this bill at all? Representative Alexander?
Mr. Chair, I move ITL.
I
Is there a
second.
Okay. You want to speak to this?
Um,
motion?
yeah, real briefly, excluding the cost, because I like to look at the costs in the Judiciary Committee as well, but I'm concerned about how we're gonna, my question regarding out of country companies, how we're gonna enforce this with Chinese companies, TikTok, that collects a ton of data on people. I also know that this committee has evaluated data privacy and data protection, and we passed some reasonable privacy protection bills recently. Right now, these bills have just been, signed and effective. So I'm hesitant to move forward with another data privacy bill until we can thoroughly evaluate how these laws are working.
Thank you. Anyone else have anything to discuss on this bill? Seeing none, I'll ask the clerk to call the roll.
Rep. Alexander.
Yes.
Rep. Tripp.
Yes.
Rep. Andrews.
Yes.
Clerk votes yes. Rep. Perez. Yes. Rep. McFarland.
Yes.
Rep. Scully.
Yes.
Rep. Ball. Yes. Rep. Birch.
Yes.
Rep. Smith. Rep. Horrigan.
Yes.
Rep. Manos. Yes. Rep. Tur.
Yes.
Rep. Rombo. Yes. Vice Chairman Mannion.
Yes.
15 yeas, 0 nays.
Any objection to consent? Seeing none, we'll go on consent. All right. Okay. Rep. Alexander, we'll write the report on it. I hereby close the executive session on House Bill 1694 FN, and we have 5 minutes before the next hearing.
No, that's okay. I was like, I will sit down.
I have very brief remarks, and then I'll just be like, but me as the president of the New Hampshire Right to Know, provide further illustration. Okay, okay. This is an exciting new initiative.
Okay, it's 11:30. I'm gonna open up the hearing on HB 1746-1030. Thank you. I'm thinking about lunch. And I recognize our Representative Saborni Shanae to introduce this bill.
Thank you, Chairman Mannion. Thank you, members of the committee. Thank you for having me again today. introducing HB 1746 this morning, subjecting taxpayer-funded investigations to the right to know law, 91 Alpha. Taxpayer-funded investigations conducted by or commissioned by public bodies are funded by taxpayers and therefore belong to the public. This is a simple bill that would allow for the minutes and records of these investigations, once completed, to be subject to the 91 Alpha. A new initiative for the state of New Hampshire in keeping with our tradition of Article 8 of the New Hampshire Constitution. Joining me today for further illustration on this bill is the President of New Hampshire Right to Know.
Hi, everyone. Thank you. Good morning, Honorable Chair and members of the House Judiciary Committee. My name is Carla Garrick, and I'm President of Right to Know New Hampshire, which is a statewide nonpartisan organization dedicated to open and transparent government. The organization has been the recipient in the past of the Nacky Loeb First Amendment Award here in New Hampshire. And you may have seen many of my colleagues over the years testify here in support of Article 8 of the New Hampshire Constitution, which of course says that our government should be open, accessible, accountable, and responsive to the people. I was a successful plaintiff in a lawsuit about 10 years ago now, actually longer. That's why my hair's gray now. It's Hirika versus Begin, which was a First Circuit case affirming the First Amendment right to film police officers in public. That was a case that is now a landmark case that is often cited in other First Amendment cases because we understand that oversight exposes wrongdoing and helps build trust. I speak today in strong support of HB 1746, which subjects taxpayer-funded investigations to New Hampshire's right to know law. This bill's findings are clear and compelling. Investigations paid for by taxpayers belong to the public. Secrecy erodes accountability and trust, and narrow redactions, as they're laid out in this bill, would protect real privacy without hiding the truth. HB 1746 adds a targeted paragraph to our 91A law. It overrides blanket exemptions in the RSA 91A5 where needed, requiring disclosure of records, reports, and materials from publicly funded probes, with redactions only if there's a federal or state requirement under things like HIPAA or some kind of statutory privilege. Those redactions would have to be narrow and would only remove what was legally required, but the findings, conclusions, and recommendations and any factual summaries cannot be withheld entirely on privacy grounds. And crucially, public officials and employees acting in their official roles get no personal privacy shield in these investigations. When you're on the public payroll, your actions on the public's dime must face public scrutiny. This isn't a radical notion. It's right here in our New Hampshire Constitution. Article 8 of the New Hampshire Constitution declares all government officials are at all times accountable to the people, and the government should be open, accessible, accountable, and responsive. The public's right to access records shall not be unreasonably restricted. Right now, loopholes exist that let secrecy hide outcomes of misconduct probes, hiring reviews, and audits that are funded by us. This breeds suspicion, rumors, and distrust. HB 1746 closes that gap responsibly. Full transparency on what matters, protected privacy where the law requires it. Pass this bill to honor our Constitution, to restore our public confidence in the office, and prove New Hampshire leads on accountable government. Thank you for your time. I'm happy to take questions.
Thank you. Any questions? Representative McFarland?
Thank you, Mr. Chairman. I have two questions. I'll come back to you for follow-up in a second. The first question, I think, Mr. Chairman, is that there is a fiscal note attached to this bill, which I assume you've had the opportunity to read. Do you do you concur? To what extent do you concur with that fiscal note? And to the extent that you don't, what do you think the fiscal impact of this bill would be if it passed into law?
So looking at the fiscal note, I think that makes sense. I mean, yes, I'll answer succinctly. I think it makes sense.
Follow up, Mr. Chairman? Follow up. My other question, and I'll use an example in this question to make it easier. When I read the bill, and especially when I read that public officials and employees acting in their official capacity shall have no right of personal privacy in such investigations, and that all of these materials would need to be made public, the first thing that jumps to my mind is the process to perform a clearance investigation on somebody federally. And I realize that we don't currently do anything exactly equivalent to that at the state level, but using that as an example, if you're putting somebody through that kind of an investigation where you are subjecting them to very personal, very intimate questions of themselves, of their associates, of their neighbors, of their family, and all of the records associated with that, would that not then be, in your opinion, excessive to release that kind of material? And where does one draw the line?
Well, I will definitely draw the line in a different place to you. But I think your example doesn't really address anything that's in this bill. You're talking about security clearance for a federal investigation, so I don't see the relevance on this. I will tell you that this bill kind of came both out of the press that we work with at Right to Know. So it's a concern for the press for open First Amendment, being able to investigate. The other things I heard on this was, I don't know how familiar the committee is with the Fenimore case, but that was overturned maybe 2-3 years ago. And that was a Supreme Court case fought by the union leader, and it took over 30 years to get it overturned. What that case basically said was there isn't a blanket get out of jail free card for personnel files of police or when there's been an action of misconduct. We all know, because we've all seen it, that sometimes there's a rotten egg in a department and then they get fired or they're asked to leave or they get their pension early. And then, I don't know, 6 months, a year later, you find them in a different town or municipality. And I think partly this bill is trying to sort of stop that as well. So when we pay for the investigations, then we should be able to see what the outcome was. And in the Fenimore case, what happened was the court said, look, we should do a balancing act, which seems reasonable. If there's something that's in the public interest, then we should disclose it because it is in the public interest. And this is just taking that sort of, not even really further, but more formally codifying it to say that if something is in the public interest and we paid for the report, they can't give us a one sentence out of the report and just say, well, this is kind of what happened. We as the public have a right under our Constitution to know and understand what truly happened in that investigation. And so I would say the public interest should always trump the private interest, especially in cases of misconduct where, yes, I understand our human nature is that we want to keep those things secret, but that is exactly when we should not be doing that.
Thank you.
Thank you. Representative Smith?
Thank you, Mr. Chairman. You mentioned a couple of circumstances that influenced this bill being written. Am I correct that in addition, this bill is relevant to a case that, or a circumstance that came out of the city of Rochester?
I'm not familiar with that.
I'd like, if I could, I'd like to ask the sponsor about that.
Not specifically, ma'am, no.
I'm sorry, I didn't hear you.
Not specifically, ma'am, no.
Could I just follow up? Well, you say not specifically, but in fact, did the situation in Rochester involving the superintendent, where there was a great deal of money expended on an investigation which continues to be private, did that not play a role in the shaping of this bill?
The decision to file this bill this is a principles-based bill, ma'am, not any one
Thank you very much.
Thank you. Any other questions? Seeing none, thank you. It's Kate Horgan.
Thank you, Mr. Chair, members of the committee. My name is Kate Horgan. I'm here on behalf of the New Hampshire Association of Counties, which represents all of your elected and appointed officials at the county government level. The association did have a chance to take a look at this bill. We think it is very broad and would likely cause significant increases to your county budgets to deal with all of these requests and redactions and reviews. You know, counties are doing a wide range of investigations from the sheriff's office to personnel, things like that. And we just have concerns about the broadness of the bill and the significant fiscal impact that this could have. I'm happy to take any questions that the committee has, but I am not a lawyer, so I just want to put that out there.
Okay, thank you. Representative Smith.
Thank you very much for being here and sharing the views of the Association of Counties. If you are going to weigh the importance of transparency in the conduct of government on the one hand, with possible costs to the government on the other hand, does one of those outweigh the other? In other words, the obligation of transparency, does that win or lose based on how much it potentially might cause a government entity to comply with transparency?
Thank you for the question, Representative Smith. I don't think one weighs out the other. I think you have to consider them together. And I think as this bill is currently written, it is far too broad and could be tightened up to ensure that the sponsor is getting the information that they want without costing significant funds to county government and ultimately the county taxpayers.
Thank you. Any other questions? Nope, seeing none.
Thank you.
Is it Chris? Chris, is it Bond? Yeah. And you have some other people with you? Okay.
Yeah, so for the record, Chris Bond, Associate Attorney General from the New Hampshire Department of Justice, and I have with me Jeff Strelzin and J.D. LaValle.
Thank you.
Good morning. Thank you for letting us speak today. For the record, my name is Jeff Strelzin. I'm prosecutor at the New Hampshire Attorney General's office, where I serve as a Senior Assistant Attorney General. I want to explain why we oppose this bill as currently written. Confidentiality is an important tool that allows law enforcement agencies to maximize their chances of success in solving criminal cases in New Hampshire. This bill would do away with that confidentiality and remove one of the most important and effective tools law enforcement has to solve crimes. Confidentiality is important in law enforcement because it ensures that witness information is based on firsthand knowledge and not made up. It helps protect witnesses from intimidation or injury or death. It gives law enforcement the chance to follow up and do investigative work. It keeps suspects from learning about the tactics and strategies that law enforcement is using and allowing those suspects to work against us. It gives us a chance to do special testing in New Hampshire and across the country if we need to. And it prevents suspects or those working with them or aligned with them from tampering with witnesses or destroying physical evidence. Confidentiality also protects the rights of innocent people unless and until there's sufficient evidence to charge and convict them. And finally, confidentiality ensures that criminal cases are tried in a courtroom where the rights of the parties can be protected so that both sides, the state and the defendant, get a fair trial. An important example of how confidentiality works to ensure fair trials is something called witness sequestration. That's a rule in the courts, and what it means is that during trials, witnesses are prohibited from listening to each other's testimony or talking to each other about their testimony. The reason that we have that rule of confidentiality, is to prevent witnesses from changing their testimony based on what other witnesses say or learning about what other witnesses might say. And what that does is it helps ensure truthfulness amongst the witnesses, and it allows judges and juries to get firsthand information from witnesses about what the witnesses themselves know versus what they've learned from someone else. Those are just some of the reasons why confidentiality is important in criminal investigations and trials. And that confidentiality would be negated by this bill and significantly reduce law enforcement's ability to solve crimes and obtain convictions. The sponsor mentioned that the bill would apply once investigations are completed. The bill does not actually say that. And so this bill would actually apply to an investigation at any stage, meaning the day after we begin it or the week after, and also would apply to criminal cases and trials, even though they're not completed. And so the bill would have very broad reach and negatively impact the confidentiality that's so important, that gives law enforcement a chance to solve cases and hold people accountable for their crimes. Those are the concerns that we have on the criminal side of our office. And my colleagues will now speak to the concerns on the civil and administrative side, and I'll be happy to take any of your questions. Thank you.
Good morning, honorable representatives. My name is J.D. LaValle. I am a Senior Assistant Attorney General and the Chief of the Department of Justice Client Counseling Unit, responsible mainly for giving advice to executive branch agencies and officials. For many of the same reasons that my colleague just spoke about, confidentiality is critical in non-criminal governmental investigations, and everything from administrative investigations of those with government-issued licenses to investigations of public officials, public employees, or agency operations. As with criminal investigations, this bill would do away with that confidentiality, undermining the integrity and effectiveness of the investigative tools deployed daily across the New Hampshire state government. Confidentiality in investigations ensures that these investigations are fair, credible, and effective. It helps ensure an unbiased and objective investigation that follows the facts. And it preserves the integrity by ensuring that witnesses do not, collude, discuss, trade stories, or prevents them from being pressured. It reduces the risk of evidence being destroyed or altered. And as my colleague discussed, premature disclosure can disrupt government operations and erode confidence, both in the subject of the investigation before any wrongdoing is established, with any degree of confidence. It protects the rights of all individuals. For example, in a workplace misconduct investigation, such as perhaps like a sexual harassment investigation, confidentiality protects the privacy and reputations of both the complainant, but also the employee being complained about. Allegations may ultimately be proven not true or unfounded. However, a premature disclosure can have lasting and irreversible effects. Confidentiality further protects the public benefit in non-disclosure, as recognized by our New Hampshire Supreme Court in Reed versus New Hampshire Attorney General's office. It encourages witnesses and whistleblowers to come forward. By doing away with the protections in 91A5, you're disincentivizing full, frank candor between officials and a culture of reporting by eliminating both the deliberative process privilege amongst officials and the attorney-client privilege. Ultimately, making all investigations public, and as this bill does at any time, because there's not a limiting principle that it must be a closed investigation, undermines investigative integrity and makes investigations subject to political pressure, sensationalism, and misinformation. So again, we object and oppose this bill because it fails to balance the public good that transparency can indeed bring with the legitimate needs and public benefits of confidentiality and integrity of our investigations. Moreover, because of the incredibly broad and unclear application of the bill, it will likely result in a resource drain on government, not only in fulfilling 91A requests at all points and processes during the investigative stage, but also perhaps through lawsuits trying to clarify what is an investigation that is publicly funded, whether it's an internal audit, whether it's a clearance background check, whether it's a employee misconduct investigation. All of those may fall within the ambit of this bill. I will now turn over the microphone to the department's general counsel for closing remarks.
Thank you. And again, for the record, Chris Bond, Associate Attorney General and General Counsel of the Department of Justice. I want to reiterate all the things that my colleagues said. I agree with everything that they've set forth here. I also did want to respond to a couple of things from the prior testimony. Jeff touched on this. I heard the word from the bill sponsor, once completed. We did not read this language as having a completion requirement in it. So that's a lot of our comments go to the fact that while an investigation was ongoing, it will be very difficult to protect the integrity of the investigation if every step of the investigation and the information was released in real time. If that wasn't the intent here, it doesn't seem to have been captured. But I will say that even if this is once closed, the removal of the I'm just pulling up 91A5 here. So 91A5 has a number of exemptions to the 91A law. They've all been removed with the narrow exception of the personal identifying information in laws such as FERPA and HIPAA. I think there's a question there whether personnel rules count as state law. There certainly are statutes about it, but there are also administrative rules. And there could be complications with that, certainly with personnel investigations. But I also wanted to respond to the concerns about real privacy can be protected. I would assert, and I think our office would assert, that there are real legitimate privacy interests that are protected by 91A5. And a lot of these are stricken. So I would encourage the members to look at the exceptions in 91A5 and think whether it really makes sense to remove them entirely in all circumstances. I'd also like to remind folks that when we do an investigation, our office is certainly not opposed to transparency, and I certainly agree with the sentiment that public employees don't have an expectation of privacy in the conduct of their duties. But when we do investigations, especially personnel investigations, we often do learn about private conduct that is truly private conduct. There is no provision in this bill that would protect that legitimate private information that we sometimes come in contact with, and that sometimes even has no bearing on the investigation. But there would be no basis based on this bill to exclude that investigation, even if it had no bearing on the conclusions of the report or was sort of a red herring. So those are the conclusion of my thoughts, and all three of us would be happy to take any questions you might have.
Thank you. I think you just answered my concern with personal privacy for the employee. You didn't think that was just their personnel file, but any personal information that's gathered or even talked about, that would become public.
I believe the way this is written, the only exceptions would be for federal and state privacy protections. Let me look at the language. I want to make sure I quote it properly. Including but not limited to FERPA and HIPAA. So those are really PHI statutes that protect certain specific categories, but there's all kinds of common law recognition of certain private conduct being private. None of that would be protected under the current draft.
Thank you. Representative Alexander?
Thank you, Mr. Chair, and I'm blessed that the Attorney General's office has come to this committee today. I would like to ask a question regarding, so from what I hear your testimony, we can get to a yes on this bill if we make a few changes. So you want to add completed investigation, right? That's what I hear, right? Because I heard about the premature. So you want to add the word upon the completion of an investigation.
That would not be sufficient because that's only one part of a criminal case. Completing the investigation doesn't mean that the case is over. There are lots of reasons why, even if you complete the investigation, you're not in a position to then bring the charges and then have the trial. So in the criminal world, it would be a combination of completing the investigation, conclusion of the trial, and appeal process if charges are brought.
I think another concern too is that sometimes we have a civil investigation, and that will conclude. But that doesn't mean, we might decide in the Civil Bureau that this is really a matter that needs to be referred to the Criminal Bureau, go to the Criminal Bureau for a new investigation, but the civil investigation would be closed. So it would be problematic for that subsequent criminal investigation if the closed civil investigation suddenly became subject to right.
Okay,
So
so
there are
I
other
understand, I get all this. You guys are lawyers, I'm not. So what I need is language to cover that. So upon final completion of the investigation, I don't know the legalese like you do. We have three well-dressed lawyers in front of me. So I want, hopefully, if you're here to testify, you're invested in getting this bill to a way to pass it. That's my first.
Mr. Chair,
Well, with all due respect,
first
we're
of all,
actually
speaking as
opposing
the
the bill.
motives of
Right.
witnesses, number one, is improper. Number two, I didn't hear that at all.
All right. I do have questions though. So
You can ask a question.
So I'm asking if you could provide the committee with language to cover the final completion of an investigation from what you stated. If you can get us to a point where I can make an amendment for this. The other thing is if we added back in the provisions from 91A5 in here, would that still kind of move the ball in the right direction, but also protect the provisions that this Judiciary Committee has long kept close to us?
I think we'd have to see what the revised language is on the part about adding in the 91A5 exemptions. That would certainly go a long way. But I want to be clear, we oppose the bill because it does away with those. I'm not sure at this point we could give you language that would allow the bill to meet the standards that you want, because we oppose it as it's written. So it's hard for us hypothetically to figure out a way to, I guess, to meet your concerns, because the bill is so broad and it does away with so many exemptions that we think what's already in the law is sufficient. Because, can I just be clear? Right now, the issue in most civil and criminal investigations is not whether the public will get the materials, it's when they will. In almost all criminal cases, I'll speak on the criminal side, the public gets the information. There are exemptions, obviously, that are currently in the law, but the issue is about timing, when they get it. And that's typically when the case is completed, sir.
Thank you. Representative McFarland?
Thank you, Mr. Chairman. So I'm sympathetic to several of the arguments that was made by the witnesses, but I would ask the counsel, Mr. Bond, to comment on the comments from his colleague that confidentiality in investigations ensures the fairness of investigations, which I find to be a very perplexing statement, and I think is perhaps part of why this bill has even been brought in the first place.
Sure. Well, I think confidentiality can serve a lot of different purposes in different times. As Jeff said, a lot of this is just about timing. So a big part of our concern, as we just went over, was our understanding that this was immediate and ongoing.
So if this were as
Let him finish the.
Yeah. So to the extent that confidentiality is a critical tool to preserve due process protections for individuals, it certainly would never be appropriate for someone accused of some sort of a heinous act to have that accusation and partial incomplete evidence out there without an opportunity for a rebuttal or an opportunity to contest that evidence. So that's one reason why, to protect the integrity of the investigation, it really has to be concluded so that everything can be put in appropriate context. And that's what we mean by confidentiality. And I think that's part of our differentiation between confidentiality and secrecy. I mean, secrecy, I think of as just keeping something private for the purpose of keeping it private. Confidentiality is keeping something non-public for an end, often due process protections. And then sometimes that does become permanent if there's a legitimate privacy interest. I'd also point out that the current state of the law is that once our investigations are closed, they are subject to right to know. And then we do make redactions based on the privacy interest in 91A5. And if anyone ever thinks that we've overexerted those privacy interests or they're not legitimate, people are free to challenge that, and courts do that balancing.
Thank you.
Representative Birch?
Thank you, Mr. Chair. Thank you, gentlemen, for being here. And as long as we've got some legal beagles here, let me ask a question. I'll try to direct it to the civil attorney. And while I'm in favor, as a retired attorney, in keeping lawyers employed. I want to ask you about two phrases in the bill. One is redacting only those portions necessary, which is line 13, and line 17, so the main page of the bill. On 17, shall be narrowly tailored. And my question to you is, that kind of language in a bill without any definitional gloss, any sense of direction, or anything, just necessary to comply with or narrowly tailored, does that speak to the fact that challenges in this bill are going to land up in court and going to be litigated endlessly in court at considerable time, effort, and expense?
Thank you, Representative. That is a great question. In a former life, in a current life as well, I'm a reserve officer in the U.S. Coast Guard. I started my career as an active duty member. So I have a lot of familiarity with FOIA, unfortunately, at the federal level. Those phrases do time and time again come up in federal litigation. And I know based off of our Supreme Court case law, sometimes we do look to the feds for guidance. That said, I think, Representative, you've hit on a great point that I think some of our concern here today is just the ambiguities contained in this bill, both the ones that you pointed out and some others that would likely lead to litigation. Now, everything in the state regarding information law and the right to know law usually leads to litigation anyway. But I think those are valid concerns, sir.
Any other questions? Representative Manos?
Thank you, Mr. Chair, and thank you for taking my question. I actually have two questions, and I wanted to know, as you read the bill as it's drafted, would this apply to grand jury proceedings? And would it apply to the Department of Children and Families, DCYF, regarding their investigation?
I think on the criminal side, on grand jury proceedings, yes, it could negate that confidentiality as well. And then I'll let my colleague answer on the other piece.
I would think with regard to DCYF, there are protections in 169 and 169C and 170 that don't seem to be peeled back the way the 91A5 exemptions are. So I think some of those confidentiality provisions would apply, but it would be an interesting and tight question if we came to have that information through an investigation. So I think that would be the problem. So the same information, if it came to us by way of an investigation, probably wouldn't have those protections, but it would if it remained cabined in its 169C proceedings. Another thing I didn't mention that I meant to touch on is the chilling effect that I think this can have. If individuals understand that any private information about themselves other than what's protected in these sort of state and federal PHI statutes will become public, the incentive for people to come forward and let people know when there's wrongdoing really is diminished. The incentive for victims to complain about harassment can be greatly diminished if they feel like all that sort of private embarrassing details might come to light. So I do worry about that chilling effect. And I did just want to point out, as JD mentioned, he has significant Coast Guard experience. He's actually was an instructor at the Coast Guard Academy for a semester. So he's got significant experience in the armed forces. Jeff has many decades experience as both a federal and state prosecutor. I have long multi-decade experience as a private sector attorney, both in like Fortune 500s with mom and pops as an in-house counsel. We've all done many, many investigations and many, many contexts. And I think we all regard appropriate confidentiality as a necessary tool to get at what's going on in an investigation. And without those protections, I think it becomes very hard to feel like witnesses would even talk to us voluntarily.
May I have a follow-up?
Yeah, follow-up.
Thank you for taking my follow-up. My follow-up question is, in the situation where, for example, a college or a university hires outside counsel to investigate, for example, allegations of sexual abuse, which we've seen, would that, as you read this bill, would that also be subject to this bill, that investigation?
if my colleagues have more information on that, I'd welcome them to answer. I know a lot of those investigations happen in the context of Title IX, so there are federal protections there. Presumably, those federal protections are left in place by this limiting language. Although, I mean, I guess there'd have to be, yeah, to the extent Title IX is a federal law protecting personal privacy, to the extent it operates that way, I think Title IX would operate as it would with its privacy protections. But I want to make very clear, we at AG's office do not represent the university system. They have their own counsel. So that's really outside, I think, of our experience. And I would encourage you to direct your question to the general counsel of their system.
Thank you. Representative Horgan?
My question is, would this possibly impede, well, especially in criminal cases, the New Hampshire Attorney General's office from cooperating with investigations by other jurisdictions, such as the federal government, like, for example, if somebody's a witness to a criminal case and you have to probably have to help the FBI in investigation, could that cause an avenue for, like, your investigation you did to help the other jurisdiction being made public with details that the jurisdiction that's bringing the doing the prosecution wouldn't normally be revealing? I don't know if that question is not as clear as I thought it was going to be, but thanks.
No, Representative, I do understand the question. The answer is yes, it would be problematic because obviously if we get information from another agency, they wouldn't want us to share it until their investigation was complete. So that would obviously have a chilling effect on cooperation amongst agencies crossing state lines, state and federal, or just with other agencies in New Hampshire. Again, that confidentiality is important, that agencies across the spectrum share that information to all try to get to the same goal, get the right answers, find out what happened. And I would imagine other agencies, especially from out of state, might not go to us, might not cooperate with us because they're concerned about that information being revealed.
Thank you.
Thanks.
Any other questions? Representative Scully?
Thank you, Mr. Chair. If this bill was revised and we did put the proviso in that the investigation would not be subject to any 91A request until after it was completed, how would we protect against somebody trying to thwart the intent of the law by simply not closing an investigation?
On the criminal side, again, I just want to reiterate that the end of the investigation is not the end of the criminal process. So that wouldn't be sufficient to protect all the confidentiality concerns that I mentioned, because if there's going to be a charge in a trial, the confidentiality needs to continue throughout that process. So that wouldn't be sufficient in the criminal world. To your point of, would people purposely not complete investigations? I can only speak to how we would do things in our office, which is that's not the way we would do business. But again, in other contexts, maybe that would be a concern, and maybe the concern would be more about the fact that people would change their habits. For instance, they might do interviews and not record them, not take any notes. They might not share information in writing so that there would be no documentation actually available for anyone to get from investigations, and it obviously would have a significant impact down the road. So I think that's kind of one of those unintended consequences of the bill that could happen, Representative.
Thank you.
Representative Tripp?
Sorry, I don't know if my colleague in the civil side wanted to.
Oh, go ahead. Sorry about that.
Sorry about that, sir. Representative, I just wanted to add, I know we've spent a lot of time here talking about closure of investigation, but the bill does cover all records or material generated in the course of an investigation, which was a concern that we actually did not touch on, but is also concerning to all three of us in terms of whether that would cover an investigative plan or notes or things of that nature. So I think, as my colleague just mentioned, even the closure of an investigation would still go through a lot of redaction and review for 91A purposes to protect the integrity of investigations and future investigations. And so it wouldn't just be something about the closure of an investigation that would be a flip of the switch.
Representative Tripp?
Thank you, Mr. Chair. Thank you for taking my question. I'm a little concerned that you would even mention that passage of this bill would, might, not would, but might change the way you conduct investigations, and that you wouldn't keep records of.
That's not what he said.
What?
Okay.
That's not what he said?
Nope, you can finish your question.
Oh.
I'll let him answer.
Okay, but like I said, I'm just a little concerned that you would even, say something like that. So do you really believe that if this bill was passed, that the record keeping of an investigation would change?
I said that our office wouldn't do business any differently, but I talked about the fact that it could impact how others do it. I could certainly see potentially other agencies or organizations, if this bill were to pass, to say, because the question was, would people do things to kind of get around it? And I could see people saying, okay, we don't want to turn over these records, so we're not going to create the records. There'd be no records to turn over. So again, it's one of those unintended consequences. I don't know if other agencies would do that, but I think there's at least that possibility that would cause other people to say, fine, we'll do our investigations, we won't reduce anything to writing, then there's nothing to turn over. Again, that's not how we operate, and I don't think that's something that we would do, but I can certainly see other agencies or organizations, I can imagine their legal counsel might advise them to say that the way to ensure confidentiality is to simply not reduce things to writing that can be turned over. I think it's a possibility.
Right. Like, for example, one of the exemptions in 91A5 is any notes or other material made for personal use that do not have an official purpose, also preliminary drafts, notes, and memoranda. So you could imagine a government entity undertaking an investigation and deciding, well, I don't want to do a preliminary draft here because if we change our conclusions, this thing might go out and be defamatory. We might get sued for defamation if this thing goes out and it turns out later from later information it wasn't accurate. So we just won't publish that. It could definitely hamstring an investigation.
Representative Horrigan.
We're just a policy committee here. We're not the finance committee, and maybe you can't answer it or not, but the case that was alluded to earlier, one of the things that's sort of been going up, being said is that the school district spent some large sum of money. I think it was $150,000. At least some were thinking well, there must have been some wrongdoing if they spent $150,000 on investigating it. But is $150,000 is that like a unusually large investigation or a medium-sized one, or is that abnormal? And maybe you could even break it down to how many person hours it would take to do a $150,000 investigation using the AG's attorneys.
Yeah, I don't know. I don't know if I'd want to speculate as to the cost for a municipal investigation and what would be typical or not typical. And I wouldn't want to speculate about what other costs would go into the investigation besides the attorney time. So I don't know. Did you have any thoughts, JD?
Representative, I think that's a wonderful question, but I think there's too much speculation. Right, the subject matter of the investigation, is it electronic based? You have to reconstitute a computer system or something like that. Is it personnel based? You're interviewing a bunch of witnesses. Those types of things can create wildly divergent costs.
Thanks. Yep.
Any other questions? Nope. Seeing none. Thank you very much.
Thank you. We appreciate it.
Anne Marie Banfield.
Good morning. For the record, Anne Marie Banfield. I'm a parental rights advocate in New Hampshire, focused on excellence in education. So this is why I'm normally not in front of you guys. However, as I read the bill, I do support it, by the way, and mainly, and I'll explain why, I particularly ask for investigations on occasion. I also assumed that this was after the investigation was concluded based on line 9. I hope that you will work with the sponsors to maybe clarify that if the language needs to be clarified, because when I ask for an investigation, and I'll explain that to you in just a moment, when I ask for an investigation, my concern is once the investigation is completed. I don't know, I can tell you I wouldn't even ask for any information while investigation is going on because, quite frankly, I'm looking for the outcome. So what I tend to do is, and by the way, when I do file 91As, I get information redacted all the time. I actually support privacy for students and things along that line. And so what I tend to do is if, for instance, there is a parent that calls me and says, you know, this is what happened at school, I will then say, okay, here's the law. I will have to ask them for information. I will file a 91A. If they send me something or information that shows that maybe somebody broke the law in the school, that's when I go to the Department of Education and I will ask them to conduct an investigation. That's where I normally take it. I take it to Diana Fenton. Once she has completed the investigation, I don't get any information. None. I'm not told whether, yes, they did violate the law or no, they didn't violate the law. I get nothing. So you're concerned about cost. Well, if I'm not told that this actually is a violation of law, then guess what I do the next time I see it? I ask for another investigation and I ask for another investigation because what it looks like to me is that there's been a law violated. But if that's not confirmed, then I'm left with asking them to continue investigation after investigation. So this is driving up your costs when I can't find out the results of that investigation. So that's why I support it. We're paying for an investigation on the possibility that somebody within the school district violated a law. And sometimes they're not big violations, but they're enough that maybe the teacher didn't know the law existed. And now it's time that, that they understand that they're acting outside the law. But that's why I support it. I think that if we're going to conduct these investigations on schools, we should know the outcome. So therefore, I'm not asking over and over and over to keep conducting investigation if it's not a violation of law. And if you need a further explanation, I could probably give you some examples. But that's what I run into. And I think that if we're going to conduct investigations to see if there is a violation of law going on, we should at least know the outcome. That is it.
Thank you. Any questions? No, seeing none, thank you very much. Major Bill Wright.
Good morning, Chairperson and members of the committee. Thank you for the opportunity to testify today. My name is Bill Bright. I'm a major with the New Hampshire State Police. I currently oversee our Investigative Services Bureau. I'm here to respectfully speak in opposition to House Bill 1746. This bill's stated purpose asserts that secrecy in public-funded investigations undermines accountability and public trust, and that narrow redactions are sufficient to protect genuine privacy interests. That framing suggests two problematic assumptions. First, the privacy interests are the only legitimate basis for withholding information, and second, the confidentiality in investigations is inherently improper. Both assumptions overlook well-established and critical considerations, including public safety, investigative integrity, and the timing of disclosures. As written, this bill does not account for when a request may be made during an investigation. From the moment an investigation begins, information is generated. Facts are incomplete and theories are actively being tested. If investigative materials are disclosed before an investigation concludes, the public may draw inaccurate or premature conclusions. More concerning, suspects may become aware of law enforcement actions and witness statements, allowing them to fabricate evidence, destroy evidence, intimidate or undermine witnesses, commit additional offenses, or tailor their conduct to evade accountability. Premature disclosure also risks tainting potential juries and undermining the fairness of judicial proceedings. While secrecy for its own sake can erode trust, appropriate and temporary withholding of information is not only responsible, it is essential to ensure investigations are complete, thorough, and accurate, and that those who commit crimes are ultimately held accountable. This legislation also fails to recognize that these issues have already been carefully examined by the New Hampshire Supreme Court. Existing case law establishes that factors beyond privacy rights must be considered when determining whether information should be released. These standards reflect decades of legal reasoning and balance transparency with safety, fairness, and effective law enforcement. HB 1746 does not incorporate or acknowledge these established principles. Additionally, the final paragraph of the bill states that public officials and employees acting in their official capacities have no right to personal privacy in such investigations. This provision directly contradicts federal FOIA case law. Courts have consistently held that public servants are not stripped of all personal privacy simply by virtue of their service. As the courts have noted, public identification can subject officials to harassment and interference both in their professional duties and in their private lives. And then finally, I would draw your attention to the fiscal note accompanying this bill. The New Hampshire State Police currently receives approximately 1,000 right to know requests each year. That number continues to grow on a yearly basis. Each request is unique and requires careful legal and factual review. Records must be located, evaluated for relevance, reviewed in full, and redacted where appropriate. This process can't be done hastily, as the consequences of improper disclosure can be severe. The majority of this work is performed by lieutenants and sergeants within our troops and special units in coordination with legal counsel. Every hour spent responding to these requests is an hour not spent investigating crimes, patrolling highways, or providing leadership to personnel in the field. If this legislation increases the volume of complexity of requests, it will further strain limited resources and reduce the capacity of law enforcement to deliver the highest level of service to the citizens of New Hampshire. So in conclusion, I believe the current right to know framework, as outlined in 91A, provides balanced, legally tested structure for transparency and accountability. It's been challenged, litigated, and refined through the courts. Discarding that framework and replacing it with the approach outlined in HB 1746 would be counterproductive to the bill's stated goals and could undermine public safety, due process, and effective law enforcement. Thank you.
Thank you. Any questions? Seeing none, thank you very much.
Thank you.
Sarah Burke Cohen.
Good morning, everyone. My name is Sarah Burke Cohen. I represent the New Hampshire Municipal Association. I'm going to keep this short just by virtue of, I think most of what I would say has already been said. The New Hampshire Municipal Association opposes this bill, although there is, the Constitution allows for transparency of the government. For the government to be held accountable by its people. It also provides and guarantees an individual's right to live free from governmental intrusion in private or personal information. That does not have anything that includes public officials. RSA 91A, as currently written, balances an individual's right to privacy with the citizen's right to transparency and accountability by its government. Essentially, this bill diminishes an individual's right to privacy. The bill is broad, including investigations, including at any point in investigation, could include the disclosure of a whistleblower for cases, which would hamper and hamstring any investigation and anything going further. I, again, will defer to some of what my colleagues who have opposed this bill already said. I don't want to repeat them, so if you have any questions, I'm happy to answer them.
Thank you. Any questions? Seeing none, thank you very much. I'm going to try my best with this one. I can't really read it well. Is it Yakov Abohan? Did I get that right? Just push the button. Thank you.
So, yeah, people went over most points that already are would be relevant to the bill. So I'll just go over a few things where I personally ran into and why I support this bill. In one case, there was an issue with the town clerk who would not provide a license plate as is required by law. I went to the county attorney to make a complaint, and basically, I was asking what happened with this investigation, what were the details, and all you get is a sentence of, oh, it was just a misunderstanding. And this is pretty common when you follow up when after investigations are done. Either you get no information at all, or you just get a brush off of some very little information that doesn't really help anything. And that's the same with that. When I went to the Attorney General's office, it was the same response. So many times it's not even clear that an investigation does take place. It seems like just a brush off of, oh yeah, we looked into it and we're all good. So if there's no information that's put out, no documents, no reports, no anything, it's many times hard to tell that anything really even happened. In another case, a police officer lied on a police report that he made, and when I made a complaint to the sergeant, and after at the end of the conversation, I asked, "Will I hear back on what were the conclusions of his investigation?" And he said, "Oh, I'm not required to release that to you." So I asked him, "How am I supposed to know that anything happened?" It's like, well, whatever. There was brought up a wouldn't agencies by Representative Scully, wouldn't agencies just keep up an investigation forever in order not to release information? I've already seen that happen when it's a issue that the agency cares a lot about. Investigations move swiftly and things are done. But when it's something that they don't care as much of or are trying to, they'll drag their feet, things take forever, the documents don't get signatures, it just goes on and on and on, all with the idea that they just won't need to release it until it's concluded. I had a complaint that went to the ombudsman, 91A ombudsman, where I made a request with the police department, and they wouldn't release information because it was under investigation. But miraculously, it became available to release the day before the deadline to answer the ombudsman complaint. So this is also pretty common with 91A requests, is you make a request and they'll just push off the deadline. Oh, we need more time. We need more time. Oh, they'll come up with one excuse, then it shifts to another. There's one exemption and there's another exemption, and they just take as anything as they can. So allowing them the forever going, the investigation is not concluded, it just continues on and on. And regarding about the ambiguity of it, it seems like when it helps police or some government agency to have something codified in a vague manner in the law, it happens. But when it comes to asking for transparency, suddenly it's very too broad, and who knows what's going to happen.
Any questions? Nope, seeing none, thank you. Lori Ortolano?
Good morning. Thank you for the opportunity to address the judiciary. My name is Lori Ortolano. I'm from Nashua. I'm also a member of Right to Know New Hampshire. Right to Know New Hampshire supports this bill, and I do as well as an individual. I want to share a couple of stories as an individual. I think I've heard the concerns. I came in a little late. Car battery was dead. It delayed me a bit. But I think I'm hoping we could strike a balance with this bill. I've listened to the concerns of privacy issues, very valid. Everyone doesn't, every government official doesn't necessarily deserve to have full disclosure on some issues. I can understand that. But we have the exemptions under RSA 91A. And I think one individual pointed out that they weren't really listed in here, but they exist already as statute. There's quite a long list of exemptions, and I am not opposed to seeing those exemptions applied. But what I am opposed to, that I do see happening right now, is that these exemptions through state agencies are being applied per se. They're being applied but in a blanket fashion. And the Supreme Court has ruled repeatedly that per se exemptions are not really acceptable. You have to review it on a case-by-case basis. And I certainly don't have any problem with investigations being completed. But I think one thing I'd like to see with this bill is if there's a report produced, then I think that report should be public and potentially any records that can be disclosed that led to the findings of that report be made public. I've had two situations that have been really challenging through the AG's office. One of them involved a complaint a friend and I submitted last December over the mismanagement of $70 million of trust fund money in Nashua. We couldn't account for the money the way we thought we should have. We felt there was commingling of some of the money in the general revenue or the general funds, and laws for public trust money have to be separately held. So we wrote up this complaint. It was accepted in December by the DOJ, and they referred to it as an investigation and encouraged us to send information, which we did. Time went by. We maintained communication. End of July, I wrote a request to find out where the investigation stood, and also, because we hadn't heard anything, could I get any kind of list or document that would show the caseload? What's the workload of this agency when it comes to complaints? That was summarily denied as protected information because it would reveal the parties involved. If a list exists and it shows, I would think for your management, you would maintain some document that says, hey, we got 30 open reports, investigations here. I don't need to know the names, but it could be titled, City of Nashua, this business, that business. You don't have to give individual names out. It's just a list. I don't think that should necessarily be withheld. And then after that, when we received a letter in August, we were told there's no investigation. There's nothing going on here for your complaint. You didn't go to the right place. Go to the county attorney's office, and we're not going to give you anything. I then wrote to the governor. I wrote to everyone, county attorney. I hit everyone, and the investigation was reopened, and a full finding report was put out in December. And they did find that Nashua mismanaged the trust fund money for donations and had not filed required state forms on their investment plans, did not have a board of trustees to manage trust fund money, which is required by statute, hadn't had one in at least 20 years. So it produced a lot of findings, and we're now waiting to see what records we can get from those findings. One of the concerns I have with agencies not wanting to disclose records is because sometimes it exposes the fact that they did not do the oversight they were supposed to do. And in this case, I think the agency, the charitable trust unit that was supposed to oversee all the forms coming in and the management of money, let Nashua slide. They hadn't submitted a investment plan since 2011, when one is supposed to be submitted annually. They signed their financial forms saying that under the pains and penalty of perjury, the Board of Trustees for the trust fund reviewed it. There was no Board of Trustees for the trust fund in Nashua. They had just been signed. And so, I think in those situations, I think records should be openly given. And if you have to redact, you redact. In this case, I don't think there's much to redact because it's just the handling of a city regarding public money, public trust fund money. The second issue I was really concerned about, and I'm still concerned about, is the unlawful practice or the unauthorized practice of law under RSA 311:7. I had a friend, Tracy Walbridge, who got caught in the crossfire of that law with a person who was not licensed in the state, who was authorized to assist her on an ombudsman claim. They ended up getting nailed on the unauthorized practice of law. It went up to the AG's office for an investigation, which can lead to criminal charges. And then it was, I don't know what happened to it. But I took an interest in that case because my city attorneys have accused me, because I represent myself pro se, as practicing unlawfully the unauthorized practice of law. I felt that the claims being made and the charges publicly made against me were not justified. And so I finally had a new judge come into Nashua in the last 6 months who's looked at the situation and twice said, hey, there's no unauthorized practice of law going on here. She's fine. She's not writing stuff for people. She's not getting paid to do anything. She represents herself. And I've never asked to represent anyone in court at all. But I'm not liked for my advocacy work in Nashua. And because I'm not liked, those in power have decided to slam that down and say it's a problem. So I'd like to see from the AG's office what they do with these investigations on the unlawful practice of law. And they've come back and said, you get nothing. We'll never give you these. They're confidential records and they can't be given out. Well, I'd like to know where they found a problem, because I'd like to see how they defined a problem and do I fit into the category of a problem. I don't want, and what they said, so I actually self-reported. I turned in a claim against myself and I said, here's the issue. Here's the attorney in the city's position. Here's the record. Here's my issue. I want you to tell me if I unlawfully practiced as an, unauthorized practice of law as an attorney. And they came back and said, you don't have a right. A citizen doesn't have a right to an investigation. You have to go through the New Hampshire Bar Association and request they take it. Actually, the RSA says any citizen can bring it forward. And I had to tell the AG that. And then they said, we're not investigating. We refuse to. And that doesn't mean you're innocent or you haven't broken the law, but we refuse to look into this. And they never did. And I to this day, I'd like to know who they've hit with that statute, who's been harmed by that statute, and when they've wrongfully gone after people with that statute. So I think there's room here to have some of these investigations and investigations that are funded by taxpayers opened for us to have some knowledge and understanding of what our government is doing when these types of complaints are made. And again, I would just remind this body that per se exemptions that are broad and blanketing there's plenty of case law in New Hampshire that's not permissible. So I think we could, strike a balance and do a better job here on helping us. It would help me understand. The lady before, Mary Ann Banfield, said, I don't know if I'm, keep saying the same thing, asking them to investigate the same thing that they've already said isn't a problem. Don't let us waste your time. We don't need to waste your time. Just let us know right away and show us your records and we won't do it again. Thank you.
Any questions? Seeing none, thank you very much. That's the last card I have for this bill. Are there anyone else that wants to speak on it that hasn't pulled a card out yet? Seeing none, I'm going to close the hearing on House Bill 1746, and we're going to move into an executive session on House Bill 1746, and I recognize Representative Smith for a motion.
Thank you very much. Thank you very much, Mr. Chairman. I would move interim study and would like to speak to my motion.
Second by Representative Alexander. You may speak.
I think this is a very important bill. I think it raises legitimate concerns. I have been committed to right to know during my entire stay in the legislature and do not want to in any way weaken that commitment. But I believe that the bill as written presents some very real problems. It's true 91A5 protections are removed. I don't think that that's the best way to handle that. I think the language about confidentiality is much too vague. Once completed, doesn't really say anything. There are issues about grand jury. There are issues about differences in criminal and civil matters. And if we were to pass this bill as it now is written, I think in the end, we will provide less transparency rather than more, so that in order to honor my commitment to right to know, I would like to ask this committee to commit to focusing on how to amend this bill in order to get to yes for the purposes of the bill as stated. Thank you, Mr. Chairman.
Thank you. Representative Alexander, do you want to speak to your second? No? Any discussion on this at all? Seeing none, I'll ask the clerk to call the roll.
Rep. Alexander.
Yes.
Rep. Tripp.
Yes.
Rep. Andrews.
Yes.
Clerk votes yes. Rep. Perez.
Yes.
Rep. McFarland.
Yes.
Rep. Scully.
Yes.
Rep. Ball.
Yes.
Rep. Birch.
Yes.
Rep. Smith.
Yes.
Rep. Horrigan.
Yes.
Rep. Manos.
Yes.
Rep. Chur.
Yes.
Rep. Rombo.
Yes.
Chairman Mannion.
Yes.
15 yeas, 0 nays.
With that, I will, oh, consent. Is any adjustments going on consent? Seeing none? And Representative Smith, will you write a report?
I'd be happy to.
Thank you. All right, with that, I'm going to close the executive session on House Bill 1746. And I'm going to turn it over to Representative Alexander because I'm going to introduce the next bill.
All right, I'm going to open up the public hearing on CACR 13, and I'll give the chairman a minute to go up, but I will recognize Representative Mannion to introduce the bill. And I see we have the former Speaker of the House here as well. Welcome. Ms. Sitek, if you could do me a favor and fill out a pink card at your earliest convenience. Perfect. Thank you very much. You know the drill.
Okay, thank you, members of the Judiciary Committee. Representative Dennis Mannion, I represent Rockingham 25 Salem. I introduced this bill after a conversation with one of my favorite constituents. This bill is relating to the Register of Probate, providing that the Office of Register of Probate and all references of such office be eliminated. The position has essentially been eliminated. It was, I believe it was merged with the courts to do it. So this is a position that's in the Constitution that we elect every election. And there's really no office or duties that this person has. So I believe this passed a few years ago from the House, went on the ballot, but it didn't quite meet the threshold to have it eliminated. So we're going to try it again. So with that, I will turn it over.
Take my card, and I have copies if you want to distribute them. Mr. Chairman and members of the committee, I'm Donna Sitek. I'm from Salem, and I'm a former Register of Rockingham County Register of Probate. And I want to thank Representative Mannion for sponsoring this housekeeping measure at my request. Historically, as he said, the Register of Probate served as the clerk of the probate court, supporting the judge in the handling of estates, guardianships, adoptions, and supervising a professional staff. In 2011, the legislature passed a comprehensive reorganization of the district and probate courts and the family division, forming the new circuit court. As part of that court reorganization, the legislature stripped away the responsibilities of the elected register of probate position and transferred them to a court employee, as all the other clerks of court are court employees. So the duties were taken over by the clerk of the probate division. All that remains of the register of probate is the title. It's enshrined in the state constitution as an elected position, along with all the other county officials. The register has no office, no phone, no desk, no computer, and no real duties, but does have an annual salary of $100. Because the office is in the Constitution, the legislature could eliminate it by statute when they passed the court reorganization bill. And since then, there have been several attempts to either restore the former position and all its duties and as part of the county government, but all those attempts failed. There have also been previous CACRs to eliminate the position, and only one made it to the ballot. In 2022, the measure got 62.8% of the vote, falling short of the necessary 2/3. I believe it was because the wording of the question didn't explain what was happening. The question read, are you in favor of amending Articles 71 and 81 of the second part of the Constitution to read? And then it just gives you what's left. In your bill, you have the benefit of strikeouts. You could see what's missing. But the question that was put to the voters didn't tell them what was missing. So we didn't get 2/3 of the people because even lawyers that I know said, I didn't vote for it because I didn't know what this is about. So we're bringing this back with a change in the question. You can see on line 20, the new question would be, are you in favor of eliminating the register of probate by amending Articles 71 and 81, second part of the Constitution? So it lets the voter know what they're doing by adopting this Constitution. So this CACR takes care of the unfinished business from 2011. And I urge you to pass it so that the voters will have a chance to complete the work that the legislature started 15 years ago. So I'd be happy to take any questions you have.
Thank you, Ms. Sytek. Any questions for the Honorable Madam Speaker? Representative Smith.
Madam Speaker, since in fact you were the speaker when I was first elected.
Long ago.
Yes, very long ago. Do you believe that the language changes that you have made are clear enough when we recognize that most voters will have no idea that the position of probate has in fact been elected? And do you believe that the language here that the Secretary of State would print would make the issue, would clarify the issue? Thank you.
I think the language from the Secretary of State is very, very helpful, but it's put in the voter's guide. And I couldn't find the voter's guide last election. I had to go online, so it's not easily available. Perhaps this year there'll be more than one constitutional amendment, and so there will be more interest in a voter's guide. But I did my best to let the voter know what they were voting on.
Thank you.
I can tell you it was really strange when I got sworn in 2016. I ran on a platform of trying to get rid of the position. I got elected, and I got sworn in with all the other county officials. I wasn't a county employee. I had nothing. All of you work on your county budgets, there's nothing in there about register of probate. It's not part of county government, so it's strange that it's still elected as part of the county lineup.
Other questions? Representative Horgan.
Thank you. Yeah, that's right. You are a state official. Your district is Hillsborough County, but you're not part of the county government. But my question is, so there are those few statutes left. So I guess you would envision that since obviously somebody's going to be elected in November 2026, that I guess the statute law would still allow that position to exist in its truncated form until such time as a cleanup bill is passed to strike all the provisions. Is that
I thought about that, and I said, oh, if this passes and they're elected, what happens? Well, the office is gone when the governor proclaims it, so I think that they don't fall into a position that has no office and no responsibility and no $100.
Other questions? I don't see any. Thank you.
Thank you.
Patrick Binder.
Thank you.
Hello, good day. My name is Patrick Binder, Manchester. I have a different opinion on this. And so I wasn't really expecting to talk on this, but I was looking at things that were happening before something else I needed to testify on. And I'm looking at this one, I go, how did this even come to be? So as she mentioned, in 2011, the legislature passed some reorganization of the courts that changed the responsibilities of the Register of Probate. So I challenge that this legislature had any power to do that. Article 70 of the New Hampshire Constitution specifically says that this office cannot be removed by the legislature. And with that clearly comes its duties and obligations. So I don't think that the 2011 bill is legal. I think it is unconstitutional. And so this process of CACR 13 is like backwards. The people would have had to remove the office before the laws in 2011 were allowed to be written and passed, or at least before they could take any effect. So I say that the Register of Probate does not have no duties and obligations. I would gladly run as a constitutional Register of Probate and show you that they absolutely do have obligations and duties, and that this legislature is not allowed to take those away. Article 90 of our Constitution was our reception clause. So that's the part of the Constitution that accepted all the common law at the time of the writing of the Constitution. With that was all the duties of the Register of Probate. The Register of Probate was added to common law as a check, a people's check on offices of profit. So because the court can profit off this, our ancestors, who were quite wise, decided to put in a check and say, okay, you actually have to elect the guy that registers all this, so that someone elected could be checking it and making sure the courts aren't just making money off people. I would appeal to this committee to think about the lessons of Chesterton's fence. This is the concept that people build fences for reasons, and you don't tear them down unless you understand those reasons. And so I would ask, I'm definitely against this. I think we actually need to do the opposite and look at the 2011 laws and rework those so that they are not misconstrued to be stripping a constitutional office of its duties and obligations.
Thank you for your testimony. Any questions for Mr. Binder? I don't see any. Thank you very much.
Thank you.
Is there anyone else here to testify on CACR 13? Seeing none, I'm going to close the public hearing on CACR 13 and hand the gavel back to the chairman. I think so.
All right, we're going to open up an executive session on CACR 13, and I recognize Representative Kutab for a motion.
I move on to pass.
Is there a second?
Second.
Representative Rombo, second. You want to speak to your motion?
No, thank you.
Okay. Representative Rombo, would you like to speak to your second?
I think it was covered. Thank you.
Okay. Any discussion on it at all? Yeah. Representative Alexander?
Yeah, real quick. I think this language is much more clear than it was before, and I think it has a real good chance of passing this year. So I hope that we can I hope that everybody helps me campaign to pass this. Thank you.
Anyone else? Representative Horgan?
Well, I'm going to be still going to be the naysayer on this. I think the office has some value. I mean, they are rather generously paid for the work they do, so it's a pretty high salary. But I think there's still some value to keeping this in the Constitution, and and we'll say even if this does, even if this CACR does, the voters to accept it as I mentioned, as the former speaker agreed with me, and I certainly hate to disagree with her. Like, I didn't serve under her, but I'm still I'm still awestruck and a little bit afraid when she comes. So I can imagine what it was like. She must have been what it was like for the people who actually served under her. So I would, so I'm just not prepared to, support this CACR, but so thanks.
Any other discussion? Seeing none, I'll ask the clerk to call the roll.
Rep. Alexander.
Yes.
Rep. Tripp.
Yes.
Rep. Andrews.
Yes.
Clerk votes yes. Rep. Perez.
Yes.
Rep. McFarland.
No.
Rep. Scully.
Yes.
Rep. Ball.
Yes.
Rep. Birch.
Yes.
Rep. Smith. Rep. Horrigan,
No.
Rep. Manos,
Yes.
Rep. Tur,
Yes.
Rep. Rombo,
Yes.
Chairman Mannion,
Yes.
13 yeas, 2 nays.
Any objection to consent? Yeah, oh yeah, that's right, correct. So, reports? She will do it. Yep.
Yeah, any minority report?
No, minority report? No, okay, that's it. I will close the executive session on CACR 13. Now we're gonna open the hearing on CACR 25, and I recognize Representative Alice Wade to introduce this bill, or CACR. Yeah. Just so everyone knows, we have a lot of, we're behind, and we have a lot of cards for this. So there's gonna be a limit of 2 minutes after the bill's introduced to anyone else that wants to testify on it. 2-minute limit, thank you.
Good morning, Mr. Chair and members of the committee. I am Representative Alice Wade here on behalf of my constituents in Stratford 15, Dover Ward 2, and I'm here today to introduce my bill to protect marriage equality in the New Hampshire Constitution. So it was only a little over 10 years ago that marriage equality was protected nationally by the Supreme Court's Obergefell decision. New Hampshire was a leading state when it came to marriage equality, and we were the 6th state to legalize gay marriage in 2009. In fact, polling over the last several years shows that Granite Staters support the right to gay marriage consistently between 75% and 82%, one of the highest in the entire country. But despite that, marriage equality is still under threat. In 2022, the Supreme Court Dobbs decision pushed the question of abortion back to the states. And we've seen how quickly states around the country have moved to restrict what was considered a national right for 50 years. In particular, in his opinion on the Dobbs decision, Justice Clarence Thomas explicitly stated that he wants the courts to revisit and likely overturn the right to marriage equality. I don't want to wait for that to happen before we take action on this. This constitutional amendment would protect interracial marriage and gay marriage based on New Hampshire's legalization laws and the Federal Respect for Marriage Act. This amendment also ensures equal treatment of all marriages and spouses under New Hampshire law. For example, the state couldn't refuse to recognize a valid marriage or assign differing rights to spouses based on those protected characteristics. Even if gay marriage remained legal in New Hampshire, there could be laws put forward to restrict adoption rights for gay couples. The only protected characteristics in this proposal are sex, sexual orientation, gender identity, and race. It doesn't change New Hampshire's existing marriage eligibility requirements laid out in RSA 457. It simply ensures that eligible couples can't be denied marriage based on discriminatory reasons. So with all that in mind, I'm here to ask the committee to support CACR 25 on behalf of our constituents who are worried that their ability to marry will be taken away. There are Granite Staters who have reached out to me that have been married for over a decade and don't know how long they'll have that right. I've heard from couples who have already started planning where they'd move to if marriage equality is overturned, leaving New Hampshire, their jobs, and their communities behind just to keep their families intact. To those who say this may not be necessary, I ask you to listen to the citizens who are terrified and who would be severely harmed by their marriages being ripped away from them. You might ask why, but I would ask why not? If there is no harm in proactively protecting these rights, why wouldn't we? I have gone over this language with attorneys and with OLS to make sure it would simply enshrine existing rights into the state constitution. I have a simple amendment that was just passed out that would remove just a very small phrase in the original CACR, specifically a phrase about recognizing marriages from other states. It was redundant with existing law and raised a couple technical concerns, So removing it just streamlines the amendment without changing its core protections. If you have any further concerns of any kind with this bill, I urge you to share those concerns with me, and I would be more than happy to address them in an amendment. We have the opportunity to protect our constituents proactively instead of reactively. We have the opportunity to guarantee the freedom to love who you love, regardless of sexual orientation, race, gender identity, or sex. As of this morning, the online testimony for CACR 25 has 493 people in support and only 7 opposed. When our constituents come to us with these concerns on an issue with overwhelming public support, I believe we should listen to them. I'll end with this. I'm engaged to be married. My fiance and I are planning our future here in New Hampshire. We want to eventually buy a house, maybe start a family, and build a life in this state. But we can't do that with certainty when a Supreme Court justice has explicitly said he wants to overturn marriage equality. I'm asking this committee to give us and the thousands of couples like us the certainty to plan our lives without fear. Thank you for hearing my testimony, and I'm happy to answer any questions.
Thank you. Any questions? Representative Alexander?
Thank you, Madam. Thank you, Mr. Chair, and thank you for taking my question. I keep saying Madam, I don't know why. Sorry about that.
The speaker.
Maybe that was it.
Yeah.
Well, thank you for taking my question. As a gay man in New Hampshire as well, you're not, anyway, as a gay man in New Hampshire, I haven't seen a single piece of legislation put forward that would repeal gay marriage or repeal marriage equality. And on top of that, if Obergefell was overturned, it would be similar to the way abortion was handed back to the states. If there's been no proposals whatsoever of rolling back marriage equality, why would we need this CACR is the first question. The second one is, do you believe that this would pass a 67% ballot initiative? Thank you.
So for your first question, there haven't been any proposals to overturn gay marriage because you can't with the Obergefell decision. So obviously you couldn't propose a law that would be against a Supreme Court decision nationally. Similarly, there weren't any or weren't really proposals to restrict abortion until Roe v. Wade was overturned with the Dobbs decision, or at least in a way that restricted it further than Roe v. Wade allowed. To your second question, on the note of support, as I said, polling for over a decade has shown well over 2/3 support in New Hampshire for marriage equality. So I believe that, yes, I do think this would pass the public ballot measure.
Thank you. Representative McFarland?
Yes, please would you clarify why you have indicated in this amendment that you regard marriage as a civil right and what your predicate for that is?
I mean, it is a civil right in the sense that it's the right for people to love who they love, and it's the right for people to get married that has historically been restricted for gay couples. And part of the civil rights movement has been moving to allow for interracial marriage, which was outlawed for many, many years. If your support for this bill might change if we simply rephrased a couple words but kept the actual purpose of the bill the same, I'm open to that. I don't want this bill to get killed over an issue about some vocab words that we could very easily flip around with an amendment. So that would be my answer.
Follow up, Mr. Chairman?
What, is it a question or are you?
Yeah, I wanted to check on that.
I don't know. Yeah. Nope. Any other questions? Seeing none, thank you.
Thank you very much.
Kim Lawrence? And again, there's a 2-minute limit on this. If you have written testimony, we will happily take that. You don't need to read it verbatim. You can kind of hit the highlights. 2-minute limit. Thank you.
I'm not even a full page, so we'll be good. Well, it is afternoon. Good afternoon, everyone. My name is Kim Lawrence. From New Hampshire for right now. I lived out west, and me and my wife, we had to come out here in 2011 to be legally married. She's from out here, but it wasn't recognized across the nation. So we know how it is to live without those protections. So that's why I feel like this is really important, especially in the landscape of things right now, that these could be overturned so fast at the quick of the eye that you're like, that's not going to happen. That's not going to happen. And here it is, it's happening. This resolution is simple and necessary. It says the right to marry is a fundamental civil right, and the New Hampshire must protect the right of every individual, regardless of sex, gender identity, sexual orientation, or race, to marry and have their marriage legally recognized. In America, the government is supposed to answer to the people, we the people. That means our civil rights should not depend on who is in power, what court presidents changes next, or what political agenda is dominating the news cycle. And in this political landscape of uncertainty, we demand protection as people who reside in New Hampshire. Families deserve stability. Children deserve stability. People deserve to know their marriages will be respected, not debated, not threatened, not treated as conditional. Marriage isn't just a symbolic. It affects medical decisions, inheritance, parental protections, and legal recognition. CACR 25 ensures New Hampshire won't create first-class and second-class marriages. Equal protection means equal treatment. No loopholes, no exceptions. New Hampshire should lead with courage and clarity. I respectfully urge the committee to vote ought to pass on CACR 25. Thank you.
Perfect timing. That's how it's done. Okay, next, any questions of this witness at all? Nope, seeing none, thank you. Is it Kaylee Michaels?
Right. So I'm not gonna be able to read what I wrote because it's not 2 minutes, but I'm gonna give you the highlights. So I definitely support everything Representative Alice Wade said. And I'm here to support the bill CACR 25. I think I'll just start with my experience. So me and my wife got married. Sorry, I'm very nervous. This past October, we had a private ceremony in the forest where we exchanged our vows. We got to take time to be really present with each other. A week later, we gathered with friends and family to celebrate our marriage. We ate and danced and soaked in what it means to be supported by our community. I'm very grateful every day I found my wife. She's very patient and kind and passionate about her work. She's committed to growing and building a meaningful life with me. She loves her friends dearly and has embraced mine as her own. She's the kind of person who shows up when things are hard. Our wedding was beautiful. And it's everything I could have hoped for. And I'm choosing to tell you about it because it reflects something very innately human. The desire to love, be seen, and build a life with somebody who feels safe. This right is worth protecting. Everyone deserves the chance to experience this kind of love and commitment, regardless of gender, identity, race, or sex. I urge you to look at what I actually wrote because there's a lot in there about what I think is important about the statistical significance of the constituency and what the people actually want. I think that there's important information about the precedent, that there is realistic threat, and why this is worth protecting. And I urge those of you who personally disagree with LGBT rights to set those aside, set those personal beliefs aside, and vote in accordance with your elected duty to represent the people of the state, to put public responsibility above your personal conviction.
That's your time.
Okay.
Thank you very much. Any questions at all? Nope, seeing none, thank you. Roberts, last name Roberts? Asha?
Okay, so honorable members of the Judiciary Committee, I'm Pasha Roberts. I live in Wilmette, New Hampshire, and I'm on the board of 603 Equality, and I am speaking in support of CACR 25. In 2009, New Hampshire was a leader in freedom. We were one of the first states to legalize same-sex marriage, and this has been a successful institution, establishing thousands of families and enjoying 80% popularity with voters from both parties. At this point in history, I and many are concerned about the stability of this legal status. We've seen recent Supreme Court decisions reverse longstanding protections, and it's clear that Obergefell versus Hodges case will easily come back into consideration. Without this amendment, the fundamental right to marry will be questioned and shaken. A marriage, it entails a complex bundle of legal associations spanning everything from adoption to taxes to death. And I'll say that marriage can be the ground for very difficult emotional and practical growth, and that this legal ground around it is part of what makes it a key human experience. This is the live free or die state. I mean, we have a long history of local control, of letting people form families as they see fit without interference from government. It's not selective for certain kinds of people. This equality is for everyone. So if you believe that Obergefell is safe, great. Obergefell is not going to be overturned, great. You should still have no problem passing this resolution. It would have no effect. This is protection. So I support this resolution and urge you to mark it as ought to pass. Let's put this on the ballot.
Thank you. Any questions? Seeing none, thank you very much. Representative Heath Howard.
Thank you, Honorable Mr. Chair and Honorable Committee members. I appreciate you taking the time to hear my testimony today in support of CACR 25. For the record, my name is State Representative Heath Howard. I represent the towns of Stratford and Barrington in Stratford District 4. And I want to be very clear. This constitutional amendment doesn't affect me. I'm a straight white cis guy dating a straight white cis woman, and I want to be very clear that the primary purpose of our Constitution is to protect the people from the government. Currently, our state constitution contains no explicit right to marry. Without this protection, we leave the door open for big government to step into our private lives and dictate the most personal in the most personal of human decisions, who we choose to spend our lives with. CACR 25 ensures that the state cannot deny or abridge this right based on an individual's sex, gender orientation, sexual orientation, or race. This amendment is about keeping the government out of your home and out of your bedroom. It mandates that no law, ordinance, or governmental action can assign differing rights or benefits to spouses based on who they are. It ensures that you have entered into a valid marriage whether you live here in New Hampshire or another state. The government must recognize it as lawful. By voting to pass this amendment, we are telling the state and our citizens that it has no business telling free people who they are and who they can marry. We are ensuring that all marriages and all spouses are afforded equal treatment under the law. And I believe that it is extremely important to making sure that we protect that right. Thank you, and I'm open to any questions.
Representative Alexander.
Thank you, Mr. Chair. Thank you for taking my question. You may or may not know, you probably do know, representatives put in unconstitutional bills all the time. And so I'm asking if you're aware of any single instance since the Obergefell decision in which a representative or a committee has passed a bill to repeal gay marriage provisions.
I would have to get back to you on that.
Any other questions? Seeing none, thank you. Amy Teravecchia, is that right? Teravecchia.
Hello, my name is Amy Teravecchia, and I'm the Executive Director of 603 Equality. And I'm also a member of the LGBTQ community, and I have several family members who also identify as members of that community. And I'm speaking to you today in support of CACR 25. I've had the privilege of growing up in a family that has always affirmed that love is love, but I also remember a time before marriage equality was the law of the land. And although those in my family who have been in loving same-sex relationships did not let the lack of marriage equality keep them from affirming their love, it did keep them from other important moments and milestones. The time before marriage equality meant added obstacles for hospital visits, for insurance coverage, for cohabitation, and much more. And CACR 25 would be a practical and pragmatic and proactive approach to protecting a lot of those important things, those privileges and rights that are afforded through marriage. It would show LGBTQ couples and families that that right cannot be taken away by the government. Should we see further challenges at the federal level, CACR 25 would enshrine what Granite Staters already know to be true in the state's constitution, that marriage equality is a fundamental civil right. I've heard from friends, from community members, from family members, growing concerns that the rhetoric, legislative initiatives, and judicial challenges at the federal level will have real-world consequences for those living in the Granite State. And this proposed constitutional amendment would enshrine what we already know to be true. What we already uphold is the law in this state. And most importantly, it would be proactively protecting New Hampshire families against a tumultuous and federal legislative landscape. So once again, I urge you to support CACR 25.
Thank you. Any questions? Representative McFarland?
Thank you, Mr. Chairman. What is your basis for asserting that marriage is a fundamental civil right?
There are certain privileges afforded to married couples, and I believe that those privileges should not be restricted on the basis of gender, sex, race.
Representative Andrews? Yep.
Thank you, and thank you for taking my question. I was just reading here that in 2015, the Obergefell and Hodges case decision by the Supreme Court recognized equality in marriage. So why is this needed?
That's a great question. We've seen attacks on the federal level already. Both legislative attacks and challenges to Obergefell. I think that it's causing a lot of concern for folks at the local level, and enshrining this in the New Hampshire State Constitution would allow folks to proceed with a sense of safety, knowing that those rights could not be redacted.
Any other questions? Representative Smith?
Thank you. Could you compare the experience with Obergefell to the experience with Roe v. Wade?
Certainly. We saw the Dobbs decision challenge Roe v. Wade, and then we've seen in this legislative session alone at the state level several different bills be introduced focusing on abortion access in the state. And I think that the overwhelming concern from the Granite Staters that I've engaged with is that similar attacks on the federal level will then open up safety concerns at the state level.
Any other questions? Seeing none, thank you. Nancy Brennan?
Good afternoon. Thank you for taking my testimony. My name is Nancy Brennan. I live in Ware. For 57 years, I have been happily married. I am a straight, cis, white woman going through life with a lot more privilege than some people have. And the only question about my marriage when I got married was the minister was upset that my husband wasn't baptized. But my dad straightened it out, and so we have had many happy years. I would like to, one of the representatives asked about bills that might overturn this. I haven't seen any in this state, but there are currently 31 states that have laws on the books that if Obergefell is overturned, they would be the law of the land. So we could see that happen in states the way that when Roe was overturned, a number of states immediately outlawed abortion. So that's one of our concerns. There have been 9 states that have tried to overturn Obergefell, and the Supreme Court has not done that yet, but it doesn't mean it's not going to happen. So this is a bill that makes sure that all of us, no matter our sex, gender, whatever, get to have marriage. And I think it's very important for all of us to support it, even if it doesn't affect us, because what affects some of us affects all of us. Thank you.
Any questions? Seeing none, thank you very much. Patrick Binder?
Hello, Patrick Binder, Manchester. I'm speaking against this bill, not because I'm not for equality before the law. I am. I think marriage is not in our Constitution mostly, right? There's only one mention of it, and that is that the courts handle cases of divorce. Other than that, I don't think the RSA's dealing with marriage are constitutional in this state, other than the divorce scenario. So I think this is inexpedient to legislate. I don't think we should be enshrining marriage as a civic right, because Article 3 of our Constitution says why we come together to form a government, and that is to protect the natural rights in Article 2. In no way is the civic privilege of getting a judge to give you or a clerk to give you a marriage license a natural right. It is really no place here. I think we should be looking more to divorce the concept of marriage, which is a holy sacrament in religious terms, from the civic union licensing that the clerk does. But I don't think in general New Hampshire should be in this business. If people did want to make this type of change, I don't think it should be done by injecting marriage into the Constitution. I think it should be done by amending Article 2 to simply include these types of sexuality or sexual preference as in Article 2 would make a lot more sense. Yeah, I think that's it.
Are there any questions? Seeing none, thank you very much. Jennifer Smith. I don't know if you were here earlier, but it's a 2-minute limit on testimony for everybody. Thank you. Push the button.
Okay, now we're on. All right. So Jennifer Smith, I am from Pembroke, New Hampshire. My wife and I have been married for 33 years, and so there was not marriage equality back then. And but her clergyman who officiated knew that I was struggling with my gender, and eventually the world caught up with the fact that not all of us are what we appear to be. So if the Supreme Court should overturn Obergefell and people don't know exactly what they want to do in New Hampshire about the status of marriages that would not be permitted to stand in the rest of the states where some people are going to outlaw gay marriage, because in every single document that I have, I am female, then that would really be confusing, difficult. There are all kinds of privileges afforded to married people that are not afforded to other people, and there's some obligations, and I think obviously the obligations are important enough that people can't get married again without having been divorced from a previous marriage, which I was. So, I think this gets so damn confusing, and there's a real threat of it. And that's why I would hope that we could enshrine this in our Constitution here in New Hampshire. That's all.
Okay, any questions? Seeing none, thank you. And Sarah Smith. Welcome, just push the button till it lights up red. Just push the button till it lights up red.
Thank
There you
you.
go. You're all set.
You just have to speak up when you're talking to me. Hi, my name's Sarah Smith. Thank you for taking my testimony. As my wife has stated, Jennifer Smith, that we've been married for 33 years, and the idea that if when it became clear she was transitioning, that one would have to divorce in order for her to do that, as marriage equality was not the law at the time. That gave us great pause because there are many, many benefits. And for instance, the federal rights include Social Security survivor benefits, tax benefits, immigration rights. Then in the state, it includes equal standing in state laws concerning adoption, child custody, inheritance, hospital visitation, and other spousal privileges, and expanded access to health insurance. All of these things affected us in different ways. As a wife, I could of her, the Social Security Administration allowed me to take the spousal benefit, which was available at that time, to take half of her Social Security benefits until I turned 70. That was a very big benefit that I took advantage of when she was my wife at the time. There's she was allowed to be on my health insurance at work, and the benefits that we got when we filed our taxes, etc. So if all this whole scenario plays out, that takes away a lot of rights and benefits based on our sex.
That's your time. I apologize.
Okay.
2-minute limit.
They're based on our benefits. I lost some time there.
Thank you.
Thank you very much
Any
for
questions
taking
at all?
my comments.
Seeing none, thank you. Anyone else here that wants to speak on CACR 25? Okay, there's a 2-minute limit on it.
Thank you, Chairman Mannion.
Yes, Representative Saley.
Thank you. For the record, I am Lauren Selig. I represent Durham, which is Stratford County District 10, and I support this bill. I believe that love is love, and that we should support two people who are legal adults who choose to marry each other, and that should be the end of the conversation about who should be allowed to get married.
Questions? Representative Alexander.
Thank you, Mr. Chair. Thank you for taking my question. Since 2014 Obergefell decision, how are you aware of any single situation in the Granite State in which a representative has put in a bill to repeal gay marriage, as representatives put in unconstitutional bills all the time, that has seen the light of day, passed a committee, received a single vote?
I would not say I've seen that yet, but I also don't believe that has anything to do with the current bill, which is to enshrine the right in our Constitution.
Thank you. Representative McFarland.
Thank you, Mr. Chairman. Are you aware that rights of conscience are already protected in our Constitution, in Article 4?
I don't see that as relevant.
Any other questions?
First of all, there's another pink card going around, but would you believe that it was exactly 17 years ago today that I was not a member of the House Judiciary Committee, but I was sitting, might even have been that same desk that they moved over from the old building, and testifying against an attempt to overturn the marriage equality law, which had just been enacted, I think, 3 weeks earlier. So, so would you believe there certainly have been attempts? I'm not sure whether they've taken place since the Obergefell decision. I haven't gone back and looked at the advanced bill search. Would you believe there certainly have been attempts to roll back the marriage equality bills after it was passed in 2009?
There are a number of constitutional amendments that I never would have thought would have been overturned, and I have already been surprised by them. So, given the way that things are going, nothing would truly surprise me anymore. But I am honored to have been able to officiate at a wedding of 2 consenting adults who happen to be of the same gender, and I'm honored to be able to continue that tradition for any 2 consenting adults who legally wish to marry.
Thank you. Any other questions? Seeing none, thank you.
Thank you. I think I kept that all with under your 3-minute
You
warning.
did. All of it was. Sarah Chadzinski. Chadzinski. Got it. Okay, there is a 2-minute limit.
Absolutely. I'll be very quick and direct. Hello, everyone. Thanks for hearing this. The matter brought up about the RSA and the fact that this is not outlined in our state constitution is exactly why we need to codify this. We are the live free or die state. We are about freedoms. We are about making sure that individual freedoms continue in this state, period. Personal beliefs set aside, marriage is a legal act. If it did not have legal ramifications, we would not be discussing it here, but it does, very directly. It is a federal and legal right, to your point, Representative, under the 14th Amendment and beyond. It is about life, liberty, and the pursuit of happiness, and we should codify this in our own state constitution. That's all I have to say about the matter.
All right, thank you. Any questions? Seeing none, thank you very much.
Thank you.
That's the last card I have on this. Oh, we have another one. Okay. Yes, please. There's a 2-minute limit as well. Just identify yourself.
Yep, Alexandra Prescott. I live in Raymond. I have been in New Hampshire my whole life. I just wanted to bring up something that I had not heard mentioned yet that I found very important. I do not know specifically about laws brought up here in New Hampshire, to your point, but I have yet to hear anyone mention the fact that although the Supreme Court has not yet made any attempts and has continued to uphold the Obergefell decision, I would like to remind everyone that in 2022, after the Roe v. Wade decision, Justice Clarence Thomas explicitly said that the right to gay marriage was next and has made his opinion on that very clear. And so I'm very worried as a young lesbian woman what that means for me. And I would feel much safer staying in my home state if I knew that I would be protected.
Thank you. Any questions? Seeing none, thank you very much.
Thank you.
Okay, that's the last card I have. So if there's no one else who wants to speak on this bill, I'm going to close the hearing on CACR 25, and we're going to break for lunch. Come back at 1:15. We'll start the next hearing. 1:15.
So just so
on House Bill 1032 and recognize Representative Horgan to introduce the bill.
Good. I'm Representative Timothy Horgan from Stratford County District 10, the town of Durham, and I'm here to introduce HB 1032. It's a got some written testimony. I guess there's enough people here I can pass it around. Makes a small change to RSA 91A-2. Basically adds something to paragraph A. That's the part of RSA 91A that allows one or more members of a public body to participate remotely in a meeting through Zoom or Microsoft Teams, or back in the old days, they used to do it just by speakerphone. So it's a narrow exemption from the physical quorum requirement. And first of all, it only, something that is in my written testimony that has come up is that it only applies to bodies which in fact have remote meetings. So it doesn't affect, for example, this body, which even though we have the technical capacity to have remote meetings, we don't. And it applies to individuals who are either disabled, experiencing disabilities, themselves experience disabilities, or have immediate, or caring for an immediate household member who is experiencing a disability. So they can, in addition to the people actually in the room, they can be now, if this bill passes, and I certainly hope it does, if it becomes passes, then they can be counted towards the quorum alongside the people who are physically in the room. So under current law, you have to physically be in the room. This would provide an exception for this group of people who otherwise whose lives are such that it may in many cases be impossible for them to come in and physically be at the meeting, but they can still very much they can still make very valuable contributions by participating remotely. So it benefits everyone, but it's especially critical for the disability community. And so I ask you to vote for it. And so no worries, this doesn't change the rules that this committee operates on or the full House. So thanks. That's my.
Okay. Any questions? Representative Smith.
Thank you very much. First, I'd like to thank the prime sponsor for providing his testimony on paper with 3 holes punched. That is so helpful
Yes,
to the committee, and I'd like to say that publicly and make that as a suggestion.
Okay, thank you.
Secondly, I'd like to make clear that the legislature exempted itself from 91A. So 91A does not apply to anyone, any of our work. But I want to ask you, when, assuming this bill passes, does this mean that the person who is now counted as part of the quorum can in fact vote?
Well, yes, they can. Yes, of course they can vote. So obviously, of course they can vote. Yes. So, and and I assume the same rules apply. Some of which are written, some are not. About how you have to be visible. They have to know who else is in the room with you, et cetera, et cetera. So those things are still in place. And as for the 3 hole punches, I've gotten compliments. This is the second compliment I've gotten in the last 18 minutes because I was testifying in another committee at 101. So you can thank HCS for that, but I may have to consider investing in some 3 hole punch paper for when I'm printing testimony at home. So don't think. So I can't really take the credit for that. It's the people across the hall at the House Committee Services who are responsible for that. So,
Representative Perez.
Thank you. Thanks for taking my question. I have 2 quick questions. Number one, do they have to? How do you? If I call in and I say I'm Tim Horgan, well, that wouldn't work. I'm Marge Smith. I'm Marge Smith. How are you going to verify that? How are you going to verify? I understand what you're doing, but how are you going to verify that that's me? If it's in a Zoom, you have to have a Zoom where they showed their face, which many people don't. that's a concern I have. And how do you know that Representative Manos isn't behind me with a knife to my back and telling me what to say and how to vote and how to vote? And I know I'm playing devil's advocate. It has nothing to do with my feelings. It's just a couple of holes that I see.
I mean, that's it. I mean, that's an issue, although I'm not sure how anybody could mistake you for Representative Smith or vice versa. You're two very distinctive personalities, and I'm not sure about some of my fellow reps, but I'm pretty sure Representative Manos wouldn't do that, and nobody else in this committee would do that. Yeah. So, I mean, that's an ongoing issue, not really solved one way or the other by this bill. But I think there haven't been any problems with the many public bodies who've been using this over the years, to the best of my knowledge.
Okay, any other questions? Representative Manos.
Thank you, Mr. Chair, and thank you for taking my question. I understood from your testimony, and maybe I'm incorrect, that's what I want to clarify, that this only applies to bodies that already have remote meetings. It doesn't state that in the text, and so I'm wondering where that comes from in terms of the bill. Thank you.
I think, oh, let's see, I printed up RSA 91A and looked at it, but it is, I believe it is elsewhere in 91A that they don't have to, but if they do, then they have this physical quorum requirement. And I actually have all 16 pages printed out here, but I'm not sure whether I'll bore you but I guess I won't waste time by sitting here and like flipping through it to see what the exact reference is. And if I'm wrong, I apologize, but I think I'm not.
Okay, Representative Tripp.
Thank you for taking my question. So the amendment or the change that you're making to RSA 91A mandates that they either have a disability or they're taking care of someone with a disability. Now, how is this going to be ascertained?
Well, you probably will just sort of have to trust but verify. I suppose theoretically, some official or some member of a board or commission might lie about this, but I think they would probably be lying about other things, and they'd be found out. Usually it's pretty well known, and also there is like an advantage usually to coming in person anyway. So like for some reason you want to abuse this section of the law and like claiming to be disabled and using that to come into every meeting without being present, I think that would probably impede your effectiveness and also like probably make it a less enjoyable experience. So that's yes, we do. I mean, it does say under the American Disabilities Act, so there is like some enforceability if somebody's just making a totally bogus claim. But I think the number of those cases would be pretty small, and so the chair of the relevant public body could probably deal with that if somebody was abusing this.
Representative McFarland.
Thank you, Mr. Chairman. Could you clarify why there should be a different treatment of a caregiver for somebody who considers themselves to be ADA qualified than a caregiver for somebody who is profoundly sick and ill and bedridden and doesn't otherwise qualify for ADA and needs assistance at home?
Well, this is, I mean, if you can come up with better language, but I think if somebody's severely ill, then that counts as a disability, even if it's not a permanent disability. I mean, this is something that was developed by. I did develop this along with advocates for the disability rights community, and this is also like similar to a bill that was introduced in the Senate and didn't quite make it over to our side of the wall, but we figured it was worth taking a second shot and seeing if we could have better luck going the other direction. So thanks.
Thank you. Any other questions? Nope, seeing none. Thank you very much. Lisa Stedman.
Thank you. My name is Lisa Stedman. I live in Troy, and I'm here to talk about this bill on behalf of the folks in my region. I've been a school board member for 16 years, and that's since before I became the mother of the 3 children, one of whom is Maxwell. Max has Down syndrome. I asked Representative Horrigan to sponsor this bill because my district's policy committee, which has 3 people, was having trouble making quorum. One of our members broke her hip, and I was already staying home as a caretaker for my son. I also sit on the Developmental Services Quality Council, where this rule is successful in practice. I put 2 and 2 together and thought this might be a good thing for everyone. I respect our state's open meeting law. I would oppose any effort to cloud transparency. So this is not that. It's in fact a fact that offering online participation options increases public participation. I believe that people serving in public office should show up in person for their constituents as often as possible, never using online participation as just a convenience. There have been seasons in our lives when my son was homebound and in a hospital setting. The school board meetings still had to happen every other Tuesday night, and I'm still needed at my committees. They count on me to be there. There are people out there like me who are qualified for office and not taking roles or not seeking re-election in situations like this. Some of the people took roles during COVID when remote was more widespread, and they've since had to resign. Many of these people have the expertise that you want to have at the table nonetheless. Qualified people who are caretakers, injured or immunocompromised, and retirees are willing to do the work. Groups all over the state are spending valuable time discussing 91A when they could be working. 3 examples that I witnessed just from this week alone. A technical advisory committee of a regional planning commission had not met quorum, and they spent 15 minutes discussing whether they could move forward with an informal meeting. The State Coordinating Council for Community Transportation, it has 5 strategic goals, and they've been wanting to make work groups for the 5 goals. They've lost 2 months talking about how they could make this work under 91A. This afternoon, I'll attend the first meeting of the State Advisory Committee on Education of Students with Disabilities, a group that hasn't met since July of 2024 because they've had trouble filling the seats with people who are willing to travel to Concord. And all 3 groups could have moved forward if they were leaning on this provision. The solution to the problem is to make it possible for more people to fill seats and count as if they're present. Committees with a high concentration of non-drivers, like those reviewing topics like disabilities or transportation, will especially benefit. Opening the door to a large pool of untapped talent will help fill vacancies and get more work done for the good of the wider community. I'm open to questions.
Thank you. Any questions? Seeing none, thank you very much. Brian Donnelly.
Yeah. Yeah. Oh, yes. Just bend it down a little bit. Thank you. Hello, thank you. Thank you so much, members of the House Judiciary Committee. Again, for the record, my name is Ryan Donnelly. I'm a policy analyst with Granite State Independent Living. GSIL is a statewide nonprofit organization that advocates and provides services for older adults and people with disabilities like me who wish to remain independent in their homes and communities. I'm speaking to you today in support of HB 1032. I love the work that I do. In addition to my policy role at GSIL, I also volunteer as a voting member of New Hampshire's statewide Independent Living Council. And I do want to stress that I am here on behalf of GSIL, but I am not here representing the Silk. The Silk does not typically weigh in on policy matters, but I did want to relate my experience as somebody who has served on a public body. As a federally mandated public body whose members are appointed by the governor, the silk is subject to New Hampshire's right to know law, which includes complying with the requirement that a quorum of members be physically present on site whenever a public meeting is held. I take my duties as a silk member seriously. However, even with the support of my very dedicated personal care attendants, the nature of my disability makes prolonged outings a challenge. Because of this, I attend most of my meetings remotely with the use of a desktop computer, webcam, and wireless headset, knowing that my circumstance runs the risk of the council not making quorum. When quorum is not met, the minutes of past meetings can't be approved, votes can't be held, and important work is held up until we can meet again. These interruptions are not only detrimental to the Silk's ongoing mission, but can also discourage the involvement of people with disabilities like me who want to play an active role in guiding public policy, but have difficulty regularly attending meetings in person through no fault of their own. I know my situation is not unique. Fortunately, House Bill 1032 provides a solution, allowing an exception to physical attendance and quorum requirements for individuals with disabilities and household members who care for them is a reasonable, practical accommodation that acknowledges a simple reality. Public bodies that serve people with disabilities are at their best when they include those who have lived experience. House Bill 1032 will support this and allow people with disabilities to serve on other public bodies as well, regardless of their ability to attend meetings on site. With this in mind, I hope the members of this committee will choose to support this legislation. Thank you for the opportunity to deliver my testimony to you and for all the hard work you perform on behalf of all New Hampshire citizens. And I'm happy to take any questions you folks might have.
Thank you. Any questions at all? Nope, seeing none, thank you very much.
Thank you.
Kristen Evans?
Thank you, Honorable Chair and members of the committee. For the record, my name is Kristen Evans, and I am the Director of Policy for ABLE New Hampshire, which is a statewide disability justice organization that works to protect and expand the civil and human rights of people with disabilities across the state. I am here today in strong support of House Bill 1032. House Bill 1032 is a necessary accessibility correction to a law that was never designed with disabled bodies, disabled lives, or caregiving realities in mind. It recognizes a fundamental truth of disability justice. A requirement can appear neutral while operating as a barrier. Under current law, public bodies generally require physical presence to count towards a quorum. For many disabled people, that requirement functions not as a procedural rule, but as a locked door. These barriers are not incidental. They are baked into the system. Chronic illness, pain, immune vulnerability, inaccessible buildings, lack of transportation, and unpredictable medical needs make physical attendance impossible for many disabled people. For caregivers, the barrier is even starker. Leaving a disabled family member unattended is not an option. It is a risk. When the law demands physical presence as a condition of service, it does not preserve transparency. It enforces exclusion. It filters out disabled people and caregivers before deliberation even begins and replaces lived experience with absence. That is not neutral governance. It is a structural denial of participation. HB 1032 does not weaken open government, it strengthens it. The right to know law already includes robust safeguards to ensure meetings are public, accessible, audible, and properly noticed. This bill does not remove those protections. It allows disabled members and caregivers to participate fully, to be counted, and to serve without having to choose between their health, their safety, their caregiving responsibilities, and their civic duty. Public service should not require people to sacrifice their bodies to be taken seriously. Democracy does not fail because someone participates remotely. It fails when entire communities are systematically barred from the table. People with disabilities bring critical perspectives shaped by navigating systems that routinely overlook access, equity, and real-world impact. When those voices are missing, decisions are poorer, less informed, and less just. HB 1032 affirms that disabled people are not merely constituents to be governed, but leaders, decision makers, and public servants whose participation matters. It moves New Hampshire closer to a democracy that reflects the people it claims to serve. I urge the committee to vote ought to pass on HB 1032. Thank you for listening to my testimony.
Thank you. Are there any questions? Nope, seeing none, thank you very much. Karen Rosenberg.
Good afternoon. I'm Karen Rosenberg. I'm the Policy Director at the Disability Rights Center, New Hampshire. Our organization is the state's protection and advocacy system for people with disabilities. And we are here, and I'm here, in strong support of HB 1032. One of our organization's core values is that we need communities that are inclusive and where there are not barriers for people with disabilities, where people with disabilities have equal access to participate in their communities, including by participating on public bodies. Under our current law, as you are now aware, unless there is an emergency, a member who is participating remotely is not counted towards the quorum. And so what happens under our current law is there's a built-in disincentive to allowing people with disabilities or who are caring with disabilities to become members of public bodies, because public bodies would then risk not being able to do their work. I experienced this personally as a former member of the State Advisory Committee for Children and Youth with Disabilities. I'm no longer a member of that committee. But when I was, for a good amount of time, the law required us to have a certain percentage of parents who cared for their students with disabilities and people with disabilities. We had to have over 51% of our membership made up of such individuals. But we had a really difficult time meeting the in-person quorum requirements. Our committee voted to allow remote participation. And, the pandemic was terrible, but what we learned is that Zoom and Teams and other remote access works. So while we were able to have the technology that would enable people to participate, the very people our committee needed to hear from, and we could contemporaneously hear them, see them, they could see us, hear us, and vote, we were unable to get our work done as a committee because we were not able to meet unless we met the physical quorum requirements. And that's true on every public body. So 1032 takes care of that issue by taking away that particular barrier for people with disabilities. Public bodies won't need to fear that if they allow someone on the public body who has a disability, they won't have to worry that, well, oh my gosh, we're not going to be able to meet quorum. So to us, it's an inclusion bill. It allows people to participate whose voices are important. It takes away a barrier to bringing individuals with disabilities and those caring for disabilities onto these public bodies. So for those reasons, I heartily encourage you to find this bill ought to pass. I'm happy to take any questions.
Thank you. Any questions? Seeing none, thank you very much.
Thank you.
That's the last card I have for this bill. Is anyone here that wants to speak on the bill that hasn't turned a pink card in yet? Seeing none, I'm going to close the hearing on House Bill 1032 and open up the hearing on House Bill 1040. And I'm going to recognize Representative Kerr, who's going to introduce the bill.
Thank you, Mr. Chair. Thank you, members of the committee, for allowing me to present House Bill 1040. Let me start by making it clear I'm not an expert on property law or the title process. The impetus for this bill actually came from a 92-year-old constituent in my town who began consistently attending my monthly office hours several years ago, actually. He's still very sharp of mind and embodies some very practical approaches that I think are characteristic in New Hampshire. We have very different views on almost everything, but his primary and persistent concern amongst all the conversations we've had has always been the issue of title theft, particularly through quitclaim deeds. So I started looking into this after our first meeting, and I learned a lot. I have become convinced of some things. First, this is a real and growing issue. Second, our state is falling behind others in this important area. And last, this is a good time for us to begin looking at our options. That said, as the title of the bill notes, this is only asking for a study committee. It's because I've also learned that there are many options already developed by other states, but little clear agreement amongst the interested parties as to which would best fit our state. I'll note that I have distributed by email this morning some of the background information to the members of the committee that support some of the statements. So one's property is often a family's largest asset. So that makes the impetus for theft high, and as is the potential for committing that theft. The theft is often does not involve taking physical property, just the value of the property. The transactions can typically be done remotely, making it hard to identify. It often involves vacant land, but more than 1 in 10 of these crimes involve currently occupied single-family homes, meaning the house's value can be taken out while you're living there. These scams often involve the elderly or target the elderly. My constituent, when I told him of the electronic notice options available to him, pulled out and showed me his flip phone and made it clear that those were not for him. So I just want to be clear, the actions that I'm discussing are already criminal in New Hampshire. The issue is that the value of the property can be stripped quickly, for example, by flipping a property once the title is recorded or using it as collateral for a loan where the bad actors cannot be traced. On June 1st, 2025, so just this past June, I was pleased to see the New Hampshire Attorney General's office issue a consumer alert warning to real estate owners to be, as and I'll quote it, diligent amidst reports of quitclaim deed fraud in New Hampshire. It listed a range of actions for individuals to take, including setting Google alerts, subscribing to fraud alerts, seeking insurance, monitoring real estate websites, and making sure that your utility bills do not stop coming. All good things, but all designed to mitigate the impact of a fraudulent filing after it happens, and they place the burden on the property owner to do these things. The National Association of Realtors conducted a 2025 deed and title fraud survey amongst states in the nation, measured the nationwide occurrence of these scams and collect feedback on policy solutions. They got input from 43 states and territories, including New Hampshire. They found that more than 3 in 5, or 60%, reported an incident of title or deed fraud that they were aware of within the past year, with the Northeast region standing out as the highest, with 92% of respondents noting at least one issue. The Realtor survey noted that the current focus nationally is primarily on prevention, with many states working on prevention policies. Scanning state actions, there are a wide range of initiatives that others have developed, and these crimes can be carried out remotely, so that makes any state that lags uniquely vulnerable. So a couple of facts that I think are important in New Hampshire: quitclaim deeds cannot be distinguished from warranty deeds in any way, or any official way. and registers of deeds have no ability to not file a deed that has been presented to them. So RSA 478:4 states that the register shall receive, file, and record the legal charges, all original deeds and instruments brought before that purpose. So there's no discretion, even if something causes suspicion. Many fraudulent filings involve out-of-state parties where the notary isn't known. It's also interesting that just under that provision, there's RSA section 478:42, which does allow registers to refer suspicious filings to county attorneys who can investigate, request further information, and even invalidate the filing if it's found to be fraudulent. But that only pertains to a lien against a property, not the deed itself. At that point, the transaction would much more likely appear valid. For example, a lien related to a loan that has been taken out. So I've shared some of the materials on what other states are doing. I'm not going to try and have the committee meeting here, but a wide range of options include adding local discretion of filing involving the public attorney, safe harbors for registers and others that take such action, quit claim deed required language to identify which ones are using this mechanism, which is uniquely vulnerable. Additional proof for out-of-state filers, known filer systems, and I'll say at the far extreme, some states, including our neighbors to the west, are also exploring the use of blockchain in the title recording process. Not recommending any of these, I'm just saying there's a wide range of choices. Some of these may have associated cost, and that should also be a factor weighed in when deciding what changes, if any, make sense for the state of New Hampshire. So I'll end by saying you can't stop all these from happening, but I believe that we can do better and we must do at least as good as the other states to avoid New Hampshire becoming a target. And with that, I will take any questions. Thank you.
Thank you. Representative Tripp?
Thank you, Mr. Chair. Thank you for taking my question. You seem to be very knowledgeable about this. Is there anything that makes people subject to having quitclaim deeds filed against them?
So if I'm understanding the question, quitclaim deeds are one mechanism for filing a deed. They're often used for what I think are characterized as simple transfers amongst family members and things along those lines. The other option is a warranty deed, which involves a more extensive title research process. A quitclaim deed basically means you're just conveying what the paper says, but you're in no way saying you actually own the thing that you're conveying. So it's an odd instrument, but it exists for convenience, I believe, and low cost for the most part. But because of that convenience and low cost and lack of sort of a background process, people have relied on that. Since I filed this bill, I've been told that it might be worth expanding this to all deeds because the phenomenon has expanded to even encompass warranty deeds in some instances. And if the committee was interested, I'd be happy to look into expanding that language. But that's and I am by no means an expert on this, but I've done a bunch of reading. So that's to the best of my understanding, why that vehicle exists and why it's exploited in the way that it is.
Thank you.
Yep.
Thank you. Any other questions? Seeing none, thank you.
Thank you.
Anyone else that wants to speak on this bill? Oh, I think I have a card. Is it Catherine Berube?
Good afternoon. My name is Catherine Barabee, distinguished members of the Judiciary Committee and Chair Mannion. I'm representing the Registry of Deeds Association. because we feel that it's important that if a study committee is created to study, this proposal or to look into quitclaim deeds, that there should be someone from the New Hampshire Bar Association Real Estate Section appointed as a committee member. I think that would be very important. There's a lot of confusion, I think, among people with regard to this, the deeds and how they're created and some of the issues, that have been brought up regarding them. So, yes.
Yes, Representative Smith.
Thank you. Thank you so much for your testimony. It is a committee. A committee will be made up only of members of the legislature. It's not a commission. The committee, if it's acting as I believe it would in a responsible way, would want very much to hear from those people you identified and many others who have an important role in this issue. But in order to move quickly, a committee makes more sense. A commission can take a year before it's fully formed. So in no way, by having a committee, does the sponsor want to eliminate the importance of the contributions of knowledgeable people. In fact, he very much would want to hear them, and that's why it's structured this way.
Well, I've learned something new. Thank you. And members of the Registry of Deeds Association have learned something new. So thank you. I appreciate that. And I'm sure that there will be consultation with regard to someone in the legal area of, of the Bar Association, hopefully in the real estate section. Any questions?
Any other questions? Representative Tripp.
Thank you, Mr. Chair. Thank you for taking my question. Have you experienced in your office any instances of the surreptitious transfer of property?
Yes, we have. It has. I've been in this position for close to 12 years, and I've had a handful of times that this has happened. I know of one case that the person did use a quitclaim deed. We were notified of that we thought that it might be fraudulent. I immediately sent it to the county attorney's office for investigation. I interpret New Hampshire RSA, I believe it's 478, at the top of my head, I had it. It was mentioned previously, 478.42, really more as a mandate for the Register of Deeds that if we believe that something is fraudulent that's been filed, or we've been given some notice of that we send it immediately to the county attorney's office for an investigation. That was done, and that person, from my understanding, was serving time as a result of that. There were several other investigations, and they, from my understanding, really went nowhere. That it was more of a familial issue, and they were resolved. So in the time that I've been there, that's what I can talk about in Stratford County.
Okay, thank you. Representative Scully.
Thank you, Chair. So you've had direct experience with this. So are the people, is this also identity theft? Do they represent the person committing the fraud representing themselves as the owner and giving it to somebody else?
Yeah, that's not been my experience. The particular case I recall was that the person actually came to the counter and they signed the name, as that they were that the property was being transferred to them. So they were just very bold about it, and they recorded the deed. And there was another one where I think they actually just signed someone else's name, and actually it was someone from a local, a town agency saw the signature and called me and said, that does not look like the signature of that person. They actually happened to know, and so we investigated it and sent it to the county attorney's office. And sure enough, it was fraudulent. So we push very strongly to be very, to take the offense on this with property owners. I've gone to several functions, such as that AARP has put out, the Scam Jam, and we are always pushing for people to sign up for what we have at our fingertips, which is called Property Fraud Alert. And that's something that as soon as something is filed with the Registry of Deeds, if your name is registered with Property Fraud Alert, then you immediately get a text or an email or a call that something has been filed. I know that doesn't stop the recording, but it can, you can immediately start taking action. So,
Thank you.
yeah, I know that's a little bit more far afield than probably what you'd be talking about.
Representative Manos?
Thank you, Mr. Chair, and thank you for taking my question. I see from your written testimony that you're an attorney. So I just wanted to ask, when this occurs, is the transaction void?
The transaction is not void until it's been determined by the court, or there's been some sort of decree, from my understanding. I'm not practicing law right now, so I'm not going to, but that's my understanding until it's been. And there is a process that we have that only the grantor's name is indexed if we believe that it's fraudulent. And so once it goes into the, goes to the county attorney's office, then we receive direction from their office on what to do legally.
Thank you. Representative Tripp, did you have another question?
No, thank you.
Okay. Any other questions? Seeing none, thank you.
Thank you.
Nancy DeAngelis? I see you have 10 minutes down here.
Yes, that's probably an overestimate.
Yeah, thank you.
We'll say 2.
We're a little bit behind schedule.
I'll be brief. Thank you so much for having me today. My name is Nancy DeAngelis. I am an assistant attorney general on the 3rd floor, so I just came down one flight. I am a prosecutor in the Elder Abuse and Exploitation Unit, which is a division of the Consumer Protection Bureau of the Attorney General's office. And I am not here in support or against the bill, but merely to provide some information from our personal experience on investigations that involve deed fraud. I thought what would be beneficial is to give you a generalized overview of a case that actually occurred. I need to be careful with not disclosing information about the specifics of it, but this is more of a composite of the case that I've investigated and in light of others that I've read about. So I will start generally by saying this actually did involve a warranty deed, and this was what you would call an impersonation version of deed fraud. So basically an impersonation of the actual owners of the property. The way this occurs is that the scammer poses as the property owner and approaches a real estate agent online to list the property. And the scammer uses an email address that looks authentic. So for example, it would be nancydangelis@outlook.com. It's not mine, but that's the name provided. Very little information is required to obtain an email address, and you can choose any name that you want. The scammer and the real estate agent never meet. They sign a listing agreement digitally. The real estate agent lists the property and secures a buyer. The real estate agent connects the scammer with an attorney. We'll call it the seller's attorney in air quotes, because of course this isn't the real seller, right? This is the scammer, but we'll call him seller's attorney. The seller's attorney communicates with the scammer by email or phone. They never meet. The seller's attorney prepares the deed to transfer the property and emails it to the scammer, who prints it. The scammer finds the name and commission information of a notary in a state that publishes notary information, impersonates the notary, forges the notary's signature, uses a fake stamp, and sends it back to their attorney. The buyer's attorney handles the paperwork that would normally be done at an in-person closing, of which there is none in this instance, essentially receiving the deed from the seller's attorney and wiring the purchase money from the buyers to a bank account that the scammer provided. The buyer's attorney records the deed. The scammer uses a bank account from which he can quickly transfer the funds before the account is flagged, opened in the name of the real owners of the property using their social security numbers, and creating a fake driver's license that looks like them. the money is gone before the owners know what happened. And they find out that they've lost title to their property when they receive a 1099-S in the mail, which would require them to report the proceeds to the IRS.
Representative Smith.
Thank you very much for coming. This committee was thrilled this morning to have 3 of your colleagues come, and for not exactly the first time, but very close to the first time, actually taking a position on a bill. And it was a breath of fresh air. We were thrilled. Can you tell me why, given your very clear and strong testimony that there's a problem out here that needs to be looked at, that you would not come in now and say, yes, the legislature ought to further investigate this matter?
It's my understanding that that, was the policy directive that I was given. I do know that the Attorney General takes this matter seriously, and that's what precipitated our press release. That's really all I can say on that issue, but I certainly will pass along your concern to my leadership.
Well, if I could, I just hope it's your concern, and if Attorney General Formella would like to explain to us why he consistently refuses to take positions on bills when you have a position, it would be very...
Yeah, this isn't the place for that. All right, any other questions? Rep. Manos.
Thank you. I just wanted to ask about the role of title insurance in this process. Thank you.
Yep, turn your mic back on.
Okay, am I back on? I want to be careful because, like my former colleague, I don't practice in the civil or the real estate realm, but I know enough to hopefully inform you. Generally speaking, title insurance does not cover prospective loss. So you cannot insure your property for fraud that may happen in the future, only for defects in title that preceded your purchase. And my understanding in Hampshire is that it's typically acquired by the lenders. However, there is a new endorsement being proposed by the, I should have brought their name, but Atlantic Title. It's a company that writes proposed endorsement language that is then either adopted or rejected by state insurance commissions, that is now giving buyers the opportunity to purchase a prospective policy which would potentially insure them for a future loss of their property. I don't know what that, I can't speak, for New Hampshire, whether that will go through or not, or how the insurance commission feels about it, but it is something the insurance carriers are contemplating.
Thank you. Follow up.
Thank you. But even retrospectively, wouldn't the title insurance company have a role in assuring, due to their underwriting, that this is a legitimate transaction?
So these are typically, it's a great question, these are typically cash sales for that very reason. And often they are at below market value so that they go real quick.
Thank you. Any other questions? Seeing none, thank you very much.
Thank you.
I have no other cards on this bill. Is anyone here that wants to speak on it that hasn't turned a card in yet? Seeing none, I'm going to close the hearing on House Bill 1040. And we're going to have I believe we're ready for an executive session on this bill. And I recognize Representative Turf to make a motion.
Thank you, Mr. Chair. I'd like to move ought to pass on House Bill 1040.
Is there a second? Seconded by Representative Smith. You wanted to discuss your motion?
No, thanks. I think it's all been said.
Representative Smith?
No, I think it's quite clear.
Okay. Representative Alexander?
Yeah, the only objection I have, and I'm going to vote for this motion, is the fact that you didn't put 3 senators on this committee. I think they're an equal body and they should be on the committee as well. 3 of them instead of 1. Thank you.
Okay, any more discussion on the bill? Seeing none, I will ask the clerk to call the roll when she's ready.
Rep. Alexander.
Yes.
Rep. Tripp.
Yes.
Rep Andrews.
Yes.
Clerk votes yes. Rep Perez.
Yes.
Rep McFarland.
Yes.
Rep Scully.
Yes.
Rep Ball.
Yes.
Rep Birch.
Yes.
Rep Smith. Rep Horrigan.
Yes.
Rep Manos.
Yes.
Rep Tur.
Yes.
Rep Rombo.
Yes.
Chairman Mannion.
Yes.
15 yeas, 0 nays.
Any objection to consent? Seeing none, we'll go on the consent calendar. Oh, just so everyone knows, reports, if I can have them by midnight tonight, so that way I can get them in right away. You'll do the majority report? All right, thank you. Okay, I'm gonna open up the hearing on House Bill 1115 and recognize Representative McFarland to introduce his bill. Just turn your button on. You're not on, your mic.
Oh, there you go. That's better. Thank you, Mr. Chairman. I would just ask, first of all, if the committee can make sure they are referencing not only the bill document itself as introduced, but also the amendment 2026-0190.
The amendment's not before us right now. Just
Say
the
again?
bill is. Just the bill is before us right now.
Okay, well, I will be testifying to the bill and to the amendment.
I would say, Representative, just indicate you have an amendment. We have it in front of us. If you could speak to the bill itself, probably would be the best.
Very good. Be happy to. So the reason for this bill, first and foremost, there is confusion in statutes today. We have a large number of references in the statute to citizens, and we do not define it clearly in any one place. And those of us around this table, the committee table here, may say, well, this is obvious. We know exactly what a New Hampshire citizen is, and I dare say that you do. But we are interested in making sure that it is interpreted appropriately by others. When we consider that in our statutes, we have the phrase citizen of the state and New Hampshire citizen and citizen of this state showing up about 20 times. And when we consider that we have citizen of the United States and United States citizen and citizen of, there's a couple of other forms of language there that show up about 50 times, it is reasonable for us to say, let's make sure everyone's on the same page as to what a New Hampshire citizen is. So what is a New Hampshire citizen? I think the US Constitution is very clear about it. The 14th Amendment indicates that state citizenship is derivative from United States citizenship and is not separate, and that a person is a citizen of a state because they are a citizen of the United States and they are domiciled in the state in question. And that is precisely the definition that I have sought to add as a uniform definition here. One of the reasons I just covered as to why we should do this. Another reason I think is one that is well known to this committee. We had a bill before us last year that sought to define New Hampshire citizen as something very different and very unconstitutional relative to what we know New Hampshire citizen to mean. And so I can by all means go into more detail on any of that. I don't want to make it more complicated than it needs to be. I think it's a straightforward definition and will avoid complication and confusion in the future. The recommendation I would make with regard to this is that as I've looked through, and I have looked through every single reference in statute that talks about citizens, there is one existing statute where I felt that some clarifying changes might be warranted, and that is RSA 110-B:81 that talks about New Hampshire Medals of Honor, where the language previously was New Hampshire citizen. And I have, in speaking with the New Hampshire National Guard and the Adjutant General, discussed forms of language that would be acceptable to them to maintain the current intent, and purpose of that statute, and that is reflected in the amendment before you. I would ask the committee to move this ought to pass with amendment, and I'm happy to yield to any questions.
Are there any questions? Seeing none, thank you.
Thank you.
Representative Wary?
Thank you, Mr. Chair and honorable committee members. I apologize for not having a written testimony ready for you. I will try and send something in tonight. I'm in support of this bill. There are a couple of historical aspects I'd like to point out that may be relevant to this. The New Hampshire Constitution, Article 11, covers election and elective franchises. In 1968, that article was amended to, quote, delete an obsolete phrase. That phrase was, in fact, born or naturalized therein. It was a change, I think, that was perhaps well-intended, but it actually had the unintended consequences of removing a citizen of New Hampshire process. And I think that has caused some confusion since then, as my colleague has alluded to in his introductory testimony. So it was this original phrase that was deleted that actually created a New Hampshire citizen by the Constitution of New Hampshire. So the only kind of recommendations I would have for this committee to perhaps consider is to establish state-specific criteria for becoming a citizen of New Hampshire, such as the born or naturalized therein, and then a mechanism for naturalization, such as an oath. If you want to become a naturalized citizen of the United States, you take an oath to the United States and its Constitution, and that's taken by immigrants to the U.S. Similarly, when we take our oath of office, we make an oath to uphold the Constitution of New Hampshire and the United States. And so a similar oath could be administered and for anyone immigrating to New Hampshire from a Commonwealth or state nearby or within our confines if they are already a U.S. citizen. I think this would return us to the original constitutional intent, and I think this would be beneficial for this committee to consider. I am in support of the bill. There is also a similar bill, House Bill 1520, which is before election law. I'm the prime sponsor, and it talks about defining citizenship for the purposes of voting. So I also bring that to the attention of the committee. I'd be happy to take any questions if it would please the committee.
Are there any questions? Nope. Seeing none, thank you very much.
You're welcome. Thank you.
Liz Tentorelli.
Thank you for this opportunity to address the committee. My name is Liz Tentorelli. I'm president of the Nonpartisan League of Women Voters of New Hampshire. And I'm confused because the testimony I wrote does not seem to match the bill language that I picked up here. And I suspect, having just listened to Representative Weary, that I'm really responding to his bill in House election law. So I'm not going to give you my written testimony because it makes no sense in terms of the language here. And I apologize for that. I thought I looked the bill up correctly. I do think that if this bill is adopted, that we make very sure that when we talk about voting, which is what my organization is most concerned with, that when we talk about a citizenship requirement, it is U.S. citizenship that is required, and that's what is in current law. A new registrant in New Hampshire must provide documentary proof of citizenship And that would be US citizenship, because right now there is no way to provide documentary proof of New Hampshire citizenship. There is no such paper that one gets. I understand the implicit connotation if you're a citizen of the US and you live in New Hampshire, domiciled in New Hampshire for legal purposes, then you are a citizen of New Hampshire. But I would be very careful to make sure that any change in this law does not require additional documentation at voter registration. So I'll go back and do more homework and try to straighten out what I got wrong, but I thank you very much for this opportunity. And if there are questions about my voting concerns, I'd be glad to answer them.
Thank you. Are there any questions? Representative Alexander.
Thank you, Mr. Chair. Thank you, Ms. Tenderelli, for taking my question. Do you believe that non-citizens of New Hampshire should be able to vote in New Hampshire elections?
Absolutely not.
Thank you.
Any other questions? Seeing none, thank you.
Thank you.
Patrick Binder. Binder.
Patrick Binder from Manchester. Thank you for hearing me. I come out in support of this bill. I think it's good to have a definition, and leaving it completely not defined in our RSAs is not good for our RSAs. I do also support, I like the idea earlier presented. I know it was that there be processes for actually becoming a citizen of the state, since we use those terms. I understand that those kind of predate the 14th Amendment to the U.S. Constitution, the whole concept of state citizenship. The 14th Amendment to the U.S. Constitution actually uses the word resides, which has a modern legal difference from domiciled. And I think domiciled is a much stronger language here. To say that you actually must have your legal residence, your legal address must be in New Hampshire in order to be considered a citizen of New Hampshire. The way the 14th Amendment is written, it kind of leaves it open to potentially being citizens of multiple states at once. And I don't think that makes any sense. So I like this because it clarifies the 14th Amendment, saying that you can only be a citizen of New Hampshire and basically no other state, because you can only be domiciled in one state. That's it.
Great, thank you. Any questions at all? Seeing none, thank you for your testimony. That is the last card I have for that bill. Is anyone here that wants to speak on it that hasn't filled a pink card out yet? Seeing none, I'm going to close the public hearing on House Bill 1115. And we have about 10 minutes or so before we open up the hearing on the next bill. So we'll take a quick break.
I will look at this and try and address anything that I think is necessary. All right. Yes, I think we'll get yes. Yeah, fortunately, I haven't. Senator, I did a little work on Senator Michael. Yeah. I made a phone for family. It was actually one. Yeah.
Sponsor, Representative David Walker.
Good afternoon. Thank you, Mr. Chairman and distinguished committee members. My name is David Walker, Representative David Walker. I'm Stratford 19 for the city of Rochester. I'm here to introduce House Bill 1156 FM to you for consideration by adding all such notices shall also be recorded at the respective county registry of deeds prior to rendering the final account, and the register of deeds shall be entitled to a charge of fee pursuant to RSA 478:17G. This bill, as amended, requires the estate administrators to notify local officials of any inheriting real estate and certify this to the probate court before filing a final account. The notice must also be recorded at the county registry of deeds, which may charge a fee. Currently, the towns and cities rely on the executor or the new owner to notify municipalities that they have an inherited property through probate. This does not always happen. By making it mandatory to go through the county register of deeds, the towns and cities will be notified in the same method they receive the transfer deeds. This will allow ownership and addresses to be changed in a timely manner. The property tax bill, the water bill, sewer bill, will be mailed to an accurate owner, allowing tax bills to be paid and possibly preventing a leaning process. Once the probate documents go through the registry, the transaction can be easily researched by any party. This change will prevent municipal offices from sending tax bills and water bills to the wrong addresses, and will also prevent title search issues when the property is resold. So with that, I'll answer any questions you might have.
Thank you. Are there any questions? Seeing none, thank you very much.
Thank you.
Jim Michaud.
Thank you very much, Mr. Chair and committee members. For the record, my name is Jim Michaud, and I'm the Chief Assessor for the town of Hudson. And as Assessor of the Assessing Department, I'm speaking in favor of this bill. We are not consistently getting these notices through the probate process, and not timely, not reliably. And we believe that by adding this one sentence, we will be helping to solve that issue. And the goal is to ensure that Registry of Deeds remains the reliable repository of ownership of real estate. The process that exists now does not ensure that, resulting in properties being billed in incorrect owners' names, property taxes not being paid timely, interest accrues, late property tax interest being borne, property owners receiving tax exemptions and tax credits for which they are not entitled. So when you're deceased, you no longer get your tax credit or tax exemption. But because we don't timely receive these notices through the probate process, it's sometimes years go by that this property is receiving credits and exemptions, and we cannot back bill once April 1st comes up. We can back bill within one tax year. That's it. So we're not saying, we're out to get the money, but we're just out to ensure that the statutes that are in place that require us to only give it tax credits and tax exemptions to those that qualify. It runs into problems with tax deferrals. Tax deferrals need to be redeemed within 9 months of the date of death. We don't know to bother the folks that are getting the property because we don't know that the owner has passed away. Also, issues involving abutters notices. Not having correct ownership is a significant problem. And so I would ask for your support on this bill and with any questions you have.
Thank you. Any questions? Seeing none? Thank you.
Thank you very much.
Brody Deshanes?
Thank you to the committee for letting me speak today. For the record, Brody Deshays with the New Hampshire Municipal Association. I haven't been back in over a year, so it's good to see you guys again in the Judiciary Committee. The New Hampshire Municipal Association requested that Representative Walker bring this bill forward on our behalf in the New Hampshire Association of Assessing Officers. And as has been aptly described, this bill simply amends RSA 554:18-A to add one simple sentence that will help some of these reporting requirements. And essentially, what it is our belief that the administrators should be recording the transfer of the deed with the registry of deeds, and that will help local and county officials, decreasing the administrative burden on local officials and ensuring that this information was shared with the registry of deeds. Long term, what this will end up doing is, as has been described, ensuring that there's proper tracking of who will receive tax exemptions, who owns the property, where bills that are sent by the municipalities, like a tax bill, water bill, electric bill, will be sent. We worked on this language with the New Hampshire Association of Counties, and the idea for this bill actually originates from an individual who serves as a register of deeds and is on the town select board. So there's a lot of support from local officials across the state to improve these reporting requirements and to ensure proper documentation gets to these local officials, so then, these processes work. So I'd be happy to answer any questions.
Thank you. Any questions? Seeing none, thank you very much.
Thank you.
Catherine Ruby? It is Barabee. Barabee. I think you corrected me the other day and I wasn't sure, but now I know.
I'll answer to both. Good afternoon. Again, my name is Catherine Barabee. Thank you, Chairman Mannion and distinguished members of the Judiciary Committee. I'm not going to repeat everything that our previous speakers have said. The New Hampshire, other than to say the New Hampshire Registry of Deeds Association is in support of this bill. It makes it very clear and apparent, who is receiving property through probate, either through inheritance or devise. And it's just a very common sense bill. If you have any questions, that's all I really wanted to add.
Any questions? That's it.
Okay,
Thank you very much. Joni McIntyre? Am I getting that right? Excellent.
Good afternoon. My name is Joni McIntyre. I am a real estate agent here in Concord with Coldwell Banker J. Hampy Associates, and I'm the vice chair of public policy at New Hampshire Association of Realtors. When I started in real estate in 2008, I was taught that the first thing you do is go to the registry of deeds when you are working with a buyer or a seller. At the time, as you can imagine, I could determine if I was going to walk into a short sale. So it was very beneficial for me to go through all those records that I could find in the registry, figure out the title, the chain of title, find out if there were liens, all of that. Today, we're way past short sales, but I'm going to the registry to find out if I might be looking at a fraud situation. And sometimes that helps me determine if the person I'm talking to is who they say they are, just by their telephone number and where they're calling from. This bill just makes perfect sense to me. It says in the bill, those persons coming into ownership of real estate through inheritance or devise. The Registry of Deeds is a chain of ownership. And it makes perfect sense for it to be there. And frankly, it makes our job a lot easier as well to see that chain. So we support this bill, and we hope you will as well.
Thank you very much. Any questions? Seeing none, thank you.
Thank you.
That's the last card I have on this bill. So anyone else here that wants to speak on it that hasn't turned a card in? Seeing none, I'm going to close the hearing on House Bill 1156. And we're going to take a break. We're going to meet separately and see if there's any bills that we can exec. Do 10 minutes good? 15? Do 10 minutes. We'll be back to see. We may or we may not, but we're going to meet separately to see if we can exec any bills here. Thank you. 10 minutes.
Oh, yeah.
going to be back in session here. I want to open up an executive session on House Bill 1156, and I recognize Representative Rombo for a motion.
Thank you, Mr. Chairman. I move HB 1156 ought to pass.
Is there a second?
I second.
Seconded by Representative Kutab. Do you want to speak to your motion?
Nope, I think we heard what we needed to hear. Thank you.
Representative Kutab, to your second? Nope. Any discussion on that bill? No? Nope. Seeing none, we'll ask the clerk to call the roll.
Rep. Alexander.
Yes.
Rep. Tripp. Rep. Andrews.
Yes.
Clerk votes yes. Rep. Perez. Oh, she's not here. Rep. McFarland.
So is this 1333?
1156.
1156.
Yes.
Rep. Scully.
Yes.
Rep. Ball. Yes. Rep. Birch.
Yes.
Rep. Smith. Rep. Horrigan.
Yes.
Rep. Manos.
Yes.
Rep. Tur.
Yes.
Rep. Rombo.
Yes.
Chairman Mannion.
Yes.
14 yeas, 0 nays.
Any objection to going on consent? Seeing none, we'll go on the consent calendar. I close the executive session on House Bill 1156. And we're going to open up an executive session on House Bill 1333. And I recognize Representative Manos for a motion.
Thank you, Mr. Chair. I would move ITL on this bill.
Is there a second?
I second.
Representative Smith seconded it. You want to speak to your motion? Representative Smith?
No.
Okay. Any discussion about 1333? Yes, Representative Kutab.
Thank you. I just wanted to say, I do think that there is an issue with the current statute not covering this particular thing. However, I think that it's not right to have under one statute it being first degree assault, and then under another statute it being first degree murder. And so I do think right now when you look at the I'm trying to see if I could pull it up real quick, the assault statute, it does say the way that it defines miscarriage, it says and not an induced abortion. It doesn't say not an induced abortion without consent. So if somebody were to drug somebody, I do not think it is currently covered under law. And I do think it's something that should be addressed at a later point. I think it could just simply be addressed by adding after the not an induced abortion, just simply adding 4 words of by 2 words with or with consent. But I think the way that the bill is written now is problematic. And so for that reason, I'm supporting the ITO.
Any other discussion? Seeing none, I'll ask the clerk to call the roll.
Rep. Alexander.
Yes.
Rep. Tripp.
Yes.
Rep. Andrews.
Yes.
Clerk votes yes. Rep. McFarland.
Yes.
Rep. Scully.
Yes.
Rep. Ball. Yes. Rep. Birch.
Yes.
Rep. Smith.
Yes.
Rep. Horrigan.
Yes.
Rep. Manos.
Yes.
Rep. Tur.
Yes.
Rep. Rombo.
Yes.
Chairman Mannion.
Yes.
14 yeas, 0 nays.
Okay, and with that, we're going to close the executive session on House Bill 1333 and open
May
up.
I just
Nope.
ask, Mr. Sorry, Mr.
Oh, I'm sorry.
Will that
Consent.
go on consent?
Yes, that will go on consent.
Thank you.
And by midnight tonight. Yeah. Copy and paste. Right, now I will close the executive session on 1333 and open up an executive session on House Bill 1436 and recognize Representative Alexander for a motion.
Thank you, Mr. Chairman. I move ITL.
Is there a second? Not everybody jump?
I'll second it.
Okay, Representative Tripp. Thank you. You want to speak to your motion?
Yeah, briefly, I think there's a lot of merit to this bill. I actually am kind of scared that like things that are in the cloud, I don't own. I thought I might have owned them if I created them, but I think there's a lot of issues with this bill. I also think this is kind of a federal issue, and I know not a lot of us have confidence in Congress, but if they were to act on something, this would be something they should act on, but not right at this time.
You want to speak to your second?
No.
Okay,
Could I ask a question?
Yes.
Is there anyone who's willing to answer?
we can try. Representative Smith?
I have problems with this bill because I have problems with the concept of the cloud. And I try to make sure that I keep my personal documents on my computer without them going to the cloud. I might be successful, I might not be, who knows? But I was thinking about something, and I know it, to try to clarify, I don't want to make a decision based on my prejudices. I was thinking about a safe deposit box. I don't happen to have one, but if I put my anything in a safe deposit box, do I have an assurance that nobody else can see what I have in that safe deposit box? Or can the bank make that available to other people?
Somebody want to answer it?
Representative McFarland.
Yeah, good. McFarland.
Thank you, Mr. Chairman. So I, as somebody who uses both the cloud and safety deposit boxes, I am not going to try and represent what the law is with regard to inspecting the contents of the safety deposit box, but I would opine that even if the contents of the safety deposit box were to be inspected, that does not mean that the data contained within encrypted containers in the safety deposit box would be yielded up.
I didn't understand.
So in other words,
I'm sorry.
Your data,
I'm
your personal information could still very readily be safe under all circumstances in the safety deposit box, whereas it becomes much harder in the cloud under certain circumstances. With that said, I don't feel that the language of the bill as it stands is where it needs to be. I would love to turn it into something that we could pass, but I worry about the metadata being rolled into it today.
Thank you.
Representative Tur.
Yeah, thank you, Mr. Chair. I just wanted to speak generally in favor of this bill. I intend to vote for it. I know that may not carry, but the question that Rep. Smith asked, I think, is really sort of what I see as the meat of this bill, which is the days of safe deposit boxes are no longer the way our world seems to operate. And these days, you know, it used to be that you'd buy a safe deposit box, you'd give the bank some money to own that. You would each have a key that you could take away, and what was in there was protected. I assume someone could subpoena the contents if that was the case. The cloud is a mix of things that you might or might not pay to use, or might not even know that you're using at the time that you use it. I think that is the challenge that I see in this bill being addressed, which is, do you have an assumption that anything that you've placed in a cloud account is actually the equivalent of something you put in an agreed safe deposit box? So I like this. I think it's narrow enough that even though it's only for our state, and I agree it would be nice if this were federalized, but you know, it could be operational because we know where the person who, because it's a subpoena, would have to know where that person lives to know that they would or wouldn't be covered by what we're doing. So that's my 2 bits on that.
Thank you. Anyone else wishes to speak on this bill? All right, seeing none, I'll ask the clerk to call the roll.
Rep. Alexander.
Yes.
Rep. Tripp.
Yes.
Rep. Andrews.
Yes.
Clerk votes yes. Rep. McFarland.
No.
Rep. Scully.
Again, the motion is ITL, correct?
Correct.
Yes.
Rep. Ball.
Yes.
Rep. Birch.
Yes.
Rep. Smith. Rep. Horrigan.
Yes.
Rep. Manos.
Yes.
Rep. Tur.
No.
Rep. Rombo.
Yes.
Chairman Mannion.
Yes.
11-3.
All right, regular calendar.
I'm sure it can, but I don't think that's proper.
I think it's best with, why not ask the three who voted against whether they want it on consent or regular?
I think that with more than two, it can't go on the consent order. Am I wrong about that?
We'll put it on the regular calendar, that way we'll have some more bills to put up in 29.
I was
And we'll
told
see
that
that.
as long as everybody agrees, it can go on.
That's what I was told as well.
That's my
I
understanding.
can text Paul Smith and ask him. It will first.
Does anyone object to it? We'll ask that question first. If that's the case, we can put it on consent, otherwise, if you have an objection, we'll leave it on the regular calendar.
Objection.
Yeah, no, I'm okay with it.
All right, and we'll see what the ruling is and we'll determine that. Let me see.
So you're doing the report. Might want to
That's
inquire
it.
if there's any minority.
Yeah, he said 3 is the max, you can do it.
Oh, okay.
On consent?
Yep.
Okay. No objection, we'll go on consent. Rep. Alexander will do a majority report, no minority report needed. All right. All right, on consent. All right, unless it's, I'm gonna close the executive session on, House Bill 1476. 36. My writing is as bad as some of the names. Any other business you want to discuss? If not, we'll conclude today's hearings. Yeah, look at that.